So
Well, good morning, everyone. I'm still waiting for a few stragglers to join. I think we have 59 people in the webinar right now, and I'm expecting maybe 15 more. So hopefully they're going to show up pretty quick, but I'll give a couple minutes for that to happen, and then we'll get started. If you would, as you're entering the webinar, please mute yourself.
Not now. Okay, tell them to give me a minute.
Okay, I would say I'm going to get started in about 2 minutes. All right. Well, I think we can go ahead and get started at least with the intro portion of everything. So, good morning, everyone, and welcome to what is the second of our AAIP continuing education classes for the 2025 season. My name is Don Stewart. I'm president of AAIP, and I'm the one that coordinates these classes for the most part. And so I welcome. It's nice to see you all either your shining faces or your nice circle with the two initials on this beautiful Arizona day. Let's see. We have a great lineup of classes today, as always. We're going to start off today talking about adult guardianship. And we have a great presenter, Nicole Penzella. I'll ask Nicole when she starts to tell a little bit about herself, but she's going to be going over some of the basics and recent updates in the field of adult guardianship. Like many of the classes that we have, we really, generally speaking, have two types of classes. We have classes that I bring people in to talk about the basics, and in hopes that maybe some of you who have been thinking about getting into a particular area like adult guardianship, for example, might get enough information that might motivate you to pursue that. And sometimes these classes are combined, basics and recent updates in the field. And that is the case with adult guardianship today, that the subject matter that Nicole is going to get into. That's going to be followed up by a presentation by Barry Goldman, who is an Arizona certified process server. He's going to talk about recent updates with process servers. And I'm sure that will relate to a lot of our businesses. Next, we're going to do another basics class, basics with living trust. And we're going to have a little bit of a focus on information gathering. And I'm going to do that class along with John Kroger. And then we'll end the day as we usually do with the ethics class. We're going to have an ethics class about CLDP ethics and customer service, and how conducting yourself in certain ways can meet your ethical obligations. And so hopefully that will end up being a fun class. I don't know if anybody's noticed, but I've tried to get away. I think for many years, the ethics portions were pretty much the same every time. And I've tried to mix it up a little and take somewhat, at least for me, our creative approaches to teaching certain subject matter. So hopefully you'll feel that way when you leave today. Now, a couple more housekeeping things I want to get into and talk about before we get started. And that's in relation to verifying your attendance at this class, as well as obtaining a certificate and also participating in the class. And let's start off with that. To participate in the class, which we welcome and I encourage you, and I know sometimes it can feel a little bit awkward in a virtual class to be participating. When we have these classes in person, we have wonderful participation. What time is it yet? Anyways, and we have okay participation with the virtual classes, but I'd love to improve that as we go on. And so, how do you participate? Certainly, you can just talk out loud, but with 70 people attending the class, that might be a little difficult to control. So what I ask that you do is use the features of Teams. You can raise your hand. There's a feature to raise your hand. There's also the chat, and I will try to keep paying attention to anybody that has a question, has their hand up, has something in the chat that they would like answered. Sometimes it will take a little bit for me to notice that, especially if it's during a class that I'm presenting at. But again, really welcome your participation, in all the different segments of the class today. Finally, and we're going to go. I just want to remind all of you and tell all of you that are maybe first-time attendees at the AAIP classes that in order to receive your certificate, I ask that you pay attention throughout the entire webinar, which the webinar goes from now until probably a little bit after 1. It's scheduled from 8 to 1. And throughout that time period, I will periodically hold up or put on the screen a verification word. And there'll be 3 times throughout the morning that I do that. And I'll give you a warning. I'll hold it up there for a long time. I'll say it to you. I'll spell it to you for you. And so make sure you write down all 3 of those verification words. And then at the end of the webinar, if you would send me an email, or you can respond to the emails that you've received to attend this class if you want, however you want to do that. But send me an email with those 3 words, and I will respond with your certificate of completion. And then I also will respond either with any handouts that are associated with the class, or as of late, because we have had a lot of handouts with some of the classes. I've put something, a Dropbox together where you can just access all that stuff. So again, make sure you pay attention to the verification words as we go through that. Still got people joining. And then the last thing I want to say, and then we'll kind of move to get started with the first presentation, is that inevitably during the class, people, for whatever reason, either by accident or on purpose, I'm not sure what it is, will drop out of the class. And so And I try to pay attention to that as we go through the morning, and when people are trying to get back into the class. And so I just want to say I will almost always recognize when somebody's waiting in the waiting room and let you back in. But occasionally, especially if I'm presenting, I might not notice that. And so, be patient. I will let you back in. If a few minutes go by and that doesn't happen, definitely email me, text me. I'm fine with that. Just kind of alert me to the fact that, hey, I can't get back in. And then every once in a while, I don't know if it's because of the larger numbers of people that attend. Every once in a while, I may have a problem with the teams where people are just have difficulty getting in, and I think I found a workaround for that when that happens. But in any case, like I said, just if I don't let you in a few minutes, you're welcome to text me or email me, and I'll notice that and start working on getting you back in. So, all right, what is the number to text? Well, it's yeah, you know what? Yeah, I'm happy to give everybody my cell phone number. So everybody has it anyway, I think. It's 602-619-4005. It's I will probably notice you emailing me first because I have a couple screens up and one of them is the screen for my emails. But if that doesn't work, by all means, text me. I do have my phone on silent, so I might not notice that as quickly as the email. All right, so let's move on to the first presentation. And I'm going to get Nicole set up and spotlight her and let her take over the webinar. So bear with me for a second while I find Nicole in here. I know she's here. Let's see, there she is. So I'm going to spotlight Nicole and let her take over. Let's see. So Nicole, you are spotlighted. So I see you. Are you ready to get going, Nicole?
Can everybody hear me?
Yep, I think so.
Okay.
I can hear you.
I do have a PowerPoint. Do I send that to you to share, Dawn, or can I share my screen?
You should be able to share it on your screen. If you have a problem with that, I will do it for you. But you should be able to share it. You are spotlighted.
Dawn, do you mind if I just send you the PowerPoint and you?
That would be fine. And you just tell me as I go through that. So yeah, email me that PowerPoint and I will.
Oh, hold on. I might have.
You should be able to share it yourself, but again, it's no problem if you want to send it to me and I'll flip through it for you.
Just a moment to fumble through. There we go. Ooh, it's gonna. Oh, that's fine. I'll give it a try.
Okay.
And then if it doesn't work, side by side.
I think just about everybody's here now finally, so it's a good time to start.
It's not working. Let me send you my PowerPoint.
Okay. All right. Where are you going to send it?
The one Dawn at AAIP. Does that work? Or legal resources?
Yeah. Either one. I got them all open.
The one that I chatted you on this morning.
Okay. Go ahead and send it and we'll.
Thank you.
Do you have an Apple computer?
I do.
Okay. I think that's the issue.
Yeah, my security settings don't like it.
Yeah. Okay. I didn't realize that, or I would have given you a heads up.
Sorry about that.
That's okay. It's no problem. Let me know when you've sent that and I'll open it right away.
I just sent it. Well, that's setting. I can go ahead and do my introduction and we can go from there.
Yeah, go ahead and get started.
Okay. Perfect. And then if worst case scenario, the PowerPoint doesn't come up, I can send it to everybody so they can take a look at it. It's got some pretty good notes. Okay, so my name's Nicole. I've been working for Arizona Legal Document Services for about, 12 years, including my internship. Officially, in 2015 is when I started working in probate and estate planning. I originally worked under Kelly DiCarlo, who's the owner of this company, and I learned family law. And I did that for about 2 years. And then I wanted to explore and see what else was available. And then I did learn some about probate and estate planning from Dawn. And from there, I started working with guardianships and informal probates and different things under the probate umbrella. And I would say since about 2015, 16 of when I started, I realized that there's a pretty immense need for guardianships in Arizona. Of the guardianship wheelhouse, there's a lot of different reasons why people would need guardianship. I deal with families who have elderly members who maybe didn't do proper planning and they now need guardianship to protect them. But I would say the bulk of what I do is there's a lot of minors who are incapacitated to a certain point or have a special need where they can't operate on their own once they turn the age of 18 and they still need continued assistance. So there's a pretty high volume of families that need services for stuff like that. With that being said, I do enjoy guardianships. I deal with Maricopa and Pinal County the most. The two counties are a bit different, but I would say I'm more well-versed in Maricopa, but about 2 to 3 times a month, I'll get a case in Pinal County. Pinal County they operate a bit different, but they're still just as nice. Don, did you get this slide?
I did. I'm ready when you are.
Okay, yeah, you can go ahead and pop it up and then go to slide number 2. Do I just let you know when I need you to switch it?
Yep. Yeah,
Okay.
just a second. And I'm going to share it right now. Okay. And so can you see it, Nicole?
I can see it.
Okay. All right. So you just tell me when to switch slides.
Okay, we can go ahead and go to slide number 2, please. Thank you. All right, so what is a guardian? So in a nutshell, a guardian is somebody who's been given a legal capacity to make decisions over somebody who can no longer make those decisions for themselves. It can be pretty much in the scope or in the wheelhouse of day-to-day life stuff. When you start looking at things outside of that, like assets, that's going to be considered a conservator. So the two really do go alongside hand by hand. But today we'll have a more focus on guardianship, and we will touch on conservatorship and what that does. Just know that procedurally, really, they're very similar. One of the main differences, it's just what you're asking for in the petition and what kind of information that client is going to have to provide to the court. There's also different reasons why somebody would need a guardian. There could be a special need, a mental illness. Sometimes it's due to chronic intoxication. And the need for guardianship isn't always permanent. You might have somebody who experiences mental health issues and is in a time in their life where they need assistance on a temporary basis, only to get the services that they need so they can then gain their independence. So most times when you're dealing with guardianship, it is on a permanent basis, but it can be temporary. That being said, there can be emergencies that arise where you need an emergency guardianship and a permanent guardianship. And like with most case types, if that arises, you're preparing 2 different document sets for the client. Temporary emergency is an expedited process. There is always going to be an attorney involved. There's not always an investigator. And when you do a temporary guardianship, it only lasts for 6 months. If you're also petitioning for permanent, then you file your permanent request as well. And that's going to be where the investigator does their part. So again, there's permanent guardianship, there's temporary guardianship, and then in that you can also file for emergency guardianship if needed. And if anybody has a question, you can raise your hand during and I'll get to it. You don't have to wait to the end or anything like that. John, would you go to the next slide for me, please? Now, when you are or when your client is appointed as guardian, it can be on a limited or a general basis. So most people, when they think of the term guardianship, they're thinking about it on a general term. And as a guardian, within reason, those decision-making scopes, those capacities, they're going to include all of the following that I'm going to list. Medical treatment, so physical health, medical treatment, education, so the person's education, living arrangements, so the guardian will be able to decide where the person that they're protecting lives, also known as the ward, so where the ward lives. Marriage, when the person can get married, when the ward can get married. Public assistance, and this would extend to like Social Security disability, things like that, DDD services that they need or may need. And then outpatient mental health care and treatment. So in Arizona, many of you are probably aware that in the scope of healthcare, there's two different types. There's physical health and then there's mental health. And then mental health has outpatient, where you go to your psychologist or psychiatrist appointment. And then they have inpatient, where it's a psychiatric hospital, an inpatient treatment setting. And we'll talk about that a little bit more, but that specific inpatient mental health treatment is looked at a bit differently through the eyes of the court than regular physical health and regular mental health that just is outpatient on a short term. The guardian is responsible for making decisions on a reasonable basis, and they're always supposed to, within reason, discuss the decisions that they're making for the protected person, for the ward. But they're not necessarily responsible for all of the ward's actions, pending that they don't do anything negligent. So it's not the same as a parent-child relationship, but it is very similar in what the guardian may be doing for the protected person or the ward. Don, would you go to the next slide for me, please? Thank you. So a conservator is basically over somebody's stuff. So a lot of times you'll have clients that will come to you and they know that they need a guardianship. They're uncertain if they need a conservatorship. Usually, in order to need a conservatorship, there's got to be a need. There's got to be something to conserve or something on the forefront that's going to be conserved, like a pending judgment or some sort of event that will occur in the future that would yield a settlement or a large lump sum that this protected person can't manage on their own. The conservators, when that is appointed through the court, it's another plate you have to spin, if you will. So again, guardian is over the person. It's over their decision making. It's over the way that this person lives and handles their affairs. When you're looking at a conservator, there has to be asset. So a lot of people will think that they need to be conservator because of the air conditioning just turned on. So if there's background noise, let me know and I'll turn that off. Or the heater. With disability, people will think that they need to become a conservator for that. And there might be a circumstance where they need to be the conservator because disability is paying the protected person or the ward a large settlement or a large sum. But in most situations, a conservatorship would not be needed for individuals that are receiving disability from Social Security because there's a payee assigned, and that payee is responsible for managing those assets. Again, this could change a bit depending on the situation, but generally speaking, Social Security would not be large enough, not be substantial enough to warrant the need for a conservator. A good example that I like to use with clients as far as the need for conservatorship is if somebody's renting an apartment, Well, that person doesn't own that apartment. That person is just living in a space. That's not an asset to that ward's name, that protected person's name. But if they own real property, if they own the apartment, then a conservatorship might be needed because the individual who's guardian may not have the capacity to operate on behalf of that asset, just over the person. So generally speaking, if they're confused on whether or not they need a conservator, a good go-to, if you don't want to refer them to talking to an attorney and seeking legal advice, have them watch the training, have them watch the conservatorship training. It gives a very in-depth background of what a conservator does and what they're managing. And if the client isn't sure of whether or not they need a conservator at that point, then have them talk to an attorney. Worst case scenario, a lot of times if they ask for the client, the person wanting to protect their loved one, if they ask for a guardianship and a conservatorship and there's nothing to conserve, the court won't award the conservatorship. They'll just award the guardianship if needed. So it doesn't make you start over. It doesn't make the case more difficult for the client. It's just going to put a little bit more on the court-appointed attorney to vet that situation to see, well, what's being conserved? Is there an actual need there? Let's go ahead and go to the next slide. And actually one more, because I did both. Perfect. Okay. So before we dig a little bit deeper into guardianship and touching lightly on conservatorship, we'll talk about other things that are closely related that clients might ask about, but definitely aren't guardianship. So power of attorney, most of you already know, is a document that's signed that you as the agent signing the document you as the principal signing the document, nominate an agent, nominate somebody to act on your behalf. And there's different kinds of power of attorney. Now, one big thing about power of attorney, especially if you have a parent with a child with special needs, is power of attorney is a great tool to assist somebody as needed. But the person signing the power of attorney, so if we're looking at an example between mom and child or parents and child, the child at the age of 18 would need to understand what it is that they're signing to the best of their capability. Or if we're looking at an elderly person that's signing the documents nominating their loved one, they really need to understand what's going on in that document and be of sound mind. It also does not give the agent, the person who's nominated to act on their loved one's behalf, final say. It the capacity of final say in most circumstances is going to remain with the principal, the person who signed the document. So if it's a situation going back to you have a minor who's now 18, if there's a power of attorney that's signed and mom says yes, but the child says no, the answer essentially is no, because that power of attorney did not assign that agent the responsibility like a guardianship would. And for some families, that's fine, but not for all families. Also, something to keep in mind, there is different types of medical power of attorney. And sometimes you will find that only a physical health mental power of attorney is signed. So it's a healthcare power of attorney, but there's nothing indicating on that document about mental health. And if somebody suffers from a crisis, from a serious mental illness that requires inpatient psychiatric treatment, I believe longer than 5 days, that power of attorney that's just for physical health may not be sufficient enough to get their loved one the help that they need if the loved one doesn't consent. So when power of attorneys are created, if they don't extend to mental health and somebody has an onset of a serious mental illness, it could, even though that power of attorney is signed, it could prompt the need for either an emergency guardianship or a permanent guardianship needed depending on the circumstance. And also with the power of attorney, it can be used as a nomination for guardianship. So if it's not clear whether or not the proposed guardian has the entitlement to act on behalf of the person they're trying to protect, but they have that signed power of attorney, that power of attorney can be used as a nomination. If there is a power of attorney that's been signed, you do want to make mention of it in your petition. You typically want to disclose the type of power of attorney, the date the power of attorney was created, any actions that were used with that power of attorney. So for the investigator and the attorney, when they go to do their part, they're aware of these other documents that exist that could impact the guardianship. Not in all cases, but it's definitely something that can come about. Let's go ahead and go on to the next slide. Supported decision-making agreements. So these are important, but you don't see them as often. And a lot of times when I've seen them, they are not used on their own. They're used in conjunction with a power of attorney. So a power of attorney will nominate somebody to act on that person's behalf. So the principal signs it, they nominate their agent, and it gives the agent the legal ability to do whatever it is the power of attorney is designating. Supported decision-making agreements are different. In essence, it's like a plan written on paper. So the family members know how they're assisting this person who might have a special need. And it's a plan that can be used within that family, within that team. It can also be given to medical professionals and different legal entities. So that company or that entity or that professional that person with a special need is dealing with understands how this person communicates with their team. So it's more of a document to help people stay organized in how somebody might need assistance. But just like with the power of attorney, the supported decision-making agreement helps that individual remain independent. That's the goal of the supported decision-making agreement. It's really more of a plan, and it's not doing anything to remove that independence from that individual. Now, unlike the power of attorney, the supported decision-making agreement, it's not enforceable in the court, and I cannot say definitively whether or not it's enough for a nomination of guardianship like a power of attorney would. You can certainly make note of it in the petition as far as its existence, but it works much differently than a power of attorney would in that scope. And again, you can do the supported decision-making agreement on your own or on their own, or it can be used in conjunction with the power of attorney as this is who I'm nominating and this is how decisions are to be made. Okay, let's go on to the next slide. Now, guardianship, probate, or juvenile court. So there are different kinds of guardianship. You have guardianship of a minor child, and then you have guardianship of an adult, and then sometimes you have guardianship of a minor to be effective at the age of 18. And when you're initially creating your pleadings, it can be a little confusing as far as what court you're filing in and how you create them. So when you have a child who is 17 and a half, about to turn 18, you really don't want the documents filed with the superior court, the probate court, before they turn 17 years and 6 months. Technically, the hearing needs to be within them turning 17 years and 6 months and the age of 18. But especially in Maricopa, what you will find out is the court usually will not set a hearing 6 months before the 18th birthday. One, because of the caseload that they have, and two, it impacts the way the annual reports are done. So although they can set the hearing prior to that, usually the hearing is within like a month, 2 months of the 18th birthday. If you have a client that really wants to get things started and they want to make sure that there's no gap, then what I usually do is I get started with the client about 17 years and 3 months, 17 years and 4 months. And that gives them a little bit of comfort because they know things are started. And it also gives them a lot of time to get the documents reviewed and signed and returned to me. So right when they turn 17 years and 6 months, we can get the documents filed. General timeline of a adult guardianship in Maricopa, I would say, is about 4 to 6 months. Usually it's closer to the 3 to 4 month mark, but there can be a delay. Sometimes the court will reschedule hearings. Sometimes the investigator's office gets behind. The court-appointed attorney's office, their office that's assigned, they normally get their part done prior to the hearing. But you will notice that certain times of the year, due to the caseload that the courts are taking on, the investigator's office will be behind. And usually it doesn't cause the hearing to be rescheduled, but it can. So it's always best to get things done sooner rather than later. And a realistic timeline to accommodate any bumps in the road is 4 to 6 months. Um, but usually right now in Maricopa, it's trending about 3 to 4 months. And that's clients signing things that when they need to, you filing things when you need to, notice being sent out, things being organized in a way where it's done on that first hearing. Now, Pinal County, they operate a lot faster. You'll file the documents with the court, and the court will usually set a hearing either that day when you file or within a couple of weeks. The future hearing date will be set, and the future hearing date is about a month, month and a half from that time the notice is sent out. So in Pinal County, budget about 2 to 3 months, average time frame, 4 months at the most. So Pinal County operates a lot faster. Sometimes that's great for the client. Also with Pinal County, while we're talking about it, the way Pinal County will process their cases is different than Maricopa. Pinal County, for the most part, is doing in-person hearings again. You can appear telephonically, but there's a process for that. But the way they standardly set hearings is going to be in person. Also, when you go to file your documents in Pinal County, what they require is going to be different than what Maricopa requires. The training for your client, the online training already has to be done, and the medical report needs to be included in your document set. Whereas in Maricopa County, the clerks are not actively looking for that at the time of filing. Also, when you file in Pinal County, as soon as you do the filing and the clerk takes the documents, the process of getting the court-appointed attorney and the investigator already starts. So the court will take full control over that, as well as setting the hearing date. That's going to be different in Maricopa. So both counties are great to deal with. Just know that in Pinal, the process takes a little less time normally, and there's more work that's done initially to get the documents prepared into the clerk, but less work that you do in the long run as far as preparing for the hearings. In Maricopa, the clerks are looking for very thorough but more minimal document sets, and you do more to get the case moving forward to prepare for the hearing. Going back to the differences between, oh, not yet. Thank you. Going back to the differences between the probate and juvenile court, guardianship, you can also file for conservatorship at the same time. The person serving as guardian can also act as conservator. So it doesn't need to be two different people filing. It can be the same person wanting that capacity if they need to. And you have to file, this is really important, you have to file where the protected person is located. So if the protected person is in Maricopa and the guardian's in Pinal, you need to file in Maricopa. The protected person also needs to remain living in Maricopa County and be present in Maricopa County for the entire duration of the guardianship. If the person is no longer present in Maricopa County, maybe they were in a hospital and they moved hospitals or something of that nature, and there's nothing that connects them to the county that you filed in, the court will not have jurisdiction to put in their orders. And not only will they not get guardianship, the family, but all of the attorney's fees, the investigator fee, the filing fee, there's no opportunity for those to be waived. And you'll have to start over in the county that that person is located. So if you have a client that is maybe in the process of moving and they don't know what county they're going to be in, you might want to let them know of that concern, because if they do change counties during the interim of the case, they could have problems getting their guardianship orders, and there could be substantial fees that have to be paid for the attorney and the investigator. Now, if you just have a kiddo who's a minor and needs a guardian until their age of 18, then you file in juvenile court. And juvenile court, we're not talking about minor guardianships today, but juvenile court, you file the documents and it's a very streamlined process. They take a lot of control for your client. They set the hearing and all of that. Now, if you have let's go ahead and go to the next slide. Thanks. And then if you have a child who has maybe they need a guardian, but they also have a judgment that's coming to them as a minor child, that conservatorship would be filed in probate court. So even though the minor child might need a guardianship, the assets themselves would be considered conservator, and that's a probate matter. So it would be a PB case number. You can get conservatorship of an adult if they're 17 and a half, about to turn 18. So if there is a judgment that's going to somebody that's about to emancipate at the age of 18, you can file at 17 and a half years. Just like with guardianship, if you have a need for conservatorship and a need for guardianship, you can file for both. It's the same process, whether guardianship is the more substantial role or conservatorship is the more substantial role. It's going to be the same process for an adult when you're asking for both capacities. Let's see here. And then with going back to the minor conservatorships, if there is a conservatorship involved and the child, once they turn 18 years of age, there's no need for a continued protection of that asset, then typically the conservatorship will terminate when they turn 18 and they can file to have their funds released. Now, if the child is 17, about to turn 18, and they do have a special need, then you'll have to file for an adult conservatorship and kind of flip that case from a juvenile conservatorship to an adult conservatorship. We can go into the next slide. Okay. We talked about the importance of the ward being in the county the entire time throughout the case, and that's really just to make sure that you're successful in getting your clients' orders, and as well as no attorney's fees or investigators' fees that could be waived, then paid. The cases involving guardians that are outside, or conservators that are outside of the county or outside of the state, that's not so much of what the court's concerned of. So the guardian can live in a different state or a different county. They don't necessarily need to be full-time where the protected person lives. Sometimes you'll have a group home that the protected person is living in, and it's in a different county than mom, dad, or guardian. We did touch on temporary guardianship versus permanent guardianship. So one thing to consider with temporary guardianship, it does expire within up to 6 months. And because permanent guardianship can take 4 to 6 months to obtain, usually if there's an emergency or something that's needed on not only a temporary and expedited basis, but a permanent basis, you're going to file those documents at the same time. So you have 2 timelines running. There'll be 2 hearings. And a lot of times when you have cases that come in as an emergency, you're preparing them, yes, for the emergency petition, for the emergency hearing coming up, but it's also going to be a lot of the work that's going to be needed for the permanent guardianship. So you're preparing 2 processes, but the bulk of that permanent guardianship process will be addressed when you prepare your client for the emergency. Something really important, it's not always needed, but it's very helpful. In order to get an emergency guardianship, you typically need some sort of documentation from a medical professional to support that request. The court does have the ability to offer the emergency guardianship on a very minimal basis to allow the guardian time to legally access those medical records depending on the circumstance. But if your client can get the health professional's report file or completed and filed with the case, or if they have current medical records indicating what's going on, that's going to be really, really important because the court needs to know from a medical perspective what is going on with this individual. The deferral and waiver application. So the courts in both Maricopa and Pinal County, the probate deferral application is going to look a lot different than what you see for family law and for different case types. And the reason for that is you have the opportunity to assist your client when they're filling out the deferral. It's not normally based off of the proposed guardian's income. Usually it's based off of the proposed ward's income. So if they're receiving no income, you can put 0. You don't have to accommodate minimum wage because in this case, they might not be capable of making minimum wage. And that deferral, depending on in Maricopa, what judge's office is assigned, that judge is going to look at the deferral application and indicate whether or not the fees for the attorney, for the investigator, the filing fees are to be waived. Now, you will have some offices that will, or divisions, that will not make a ruling on anything other than the attorney's fees. They won't address the filing fee and they won't address the investigator's fee. And then about a month after the hearing concludes, the guardians will get a bill for those fees. The filing fee in Maricopa is $306 and the investigator's fee, I believe, is still $400. When that happens, the court accountant knows based off of the minute entries and the orders that were put in onto record that the fees are to be waived, but they don't have the capacity of doing that because of the way the judge did their minute entry or their order. So in situations where individuals were found to be incapacitated and indigent, meaning that they don't have the means to pay for these things, a lot of times those are the cases where the attorney's fees are waived, then a supplemental deferral application would be signed, again, using the proposed ward's income. And whenever the deferral application is signed, it's signed by the proposed guardian. So the guardian is signing it on behalf of the proposed protected person using their financial information. They're filling it out using their income. If they're on disability, it's a lot easier to get things waived because obviously you submit the letter. But if they're not on disability, that's not the only requirement that qualifies them for a waiver. So just keep in mind the deferral application, you don't have to file it with the beginning of the guardianship case. It's very common to have it filed in the beginning of the guardianship case, and it's going to be based off of the proposed protected person's income. In cases where there's a conservatorship involved, that might not be true because when you're asking for a conservatorship, you're asking for that asset to be conserved. So you're indicating that there is something there to protect. You can certainly fill out the deferral application using the proposed ward's income, but as far as the ability or the ease of getting the court fee, the filing fee, and the attorney's fees waived is going to change because in the documents and in the lifestyle of the individual, it's indicating that there is asset. If they do collect the filing fee and the investigator's fees, the attorney's fees, all of that, sometimes it's paid in full, sometimes it's paid in part. The court would determine those assets to be paid. We don't have a high volume in our office of guardianships and conservatorships with substantial asset. We deal with more individuals who don't have a lot of substantial asset and usually don't have enough income to pay for these fees. And my understanding is that the fees are, when they are waived, they're waived in the matter and then the county will pay them. So it's not that they go away, they just are paid by the county. All right, we can go to the next slide. Okay, and then there is mental health court. So guardianship in Maricopa County and I believe in Pinal County is going to be considered a different kind of order than you'll see when somebody is involved with mental health court. Sometimes you'll see somebody that was involved with the mental health court and they're given court-ordered treatment. And in that ruling, in that situation, the loved one that is overseeing the proposed ward, the protected person, will also need to file for guardianship in the superior court. So mental health court is court-ordered treatment. Usually you're dealing with behavioral health hospitals, and sometimes those institutions will yield a need for usually an emergency guardianship as well as a permanent guardianship. Again, you would just make mention of those mental health orders in existence or the situation that's in existence, and then the court will use that to determine the need for guardianship. With the medical report, it needs to be a doctor or an MD. It can no longer be a physician's assistant or a nurse practitioner. So there was a very long time where any medical professional licensed in Arizona could complete the report within reason, but the court would accept a nurse practitioner or a physician's assistant or a psychiatric nurse practitioner's report to determine incapacity. This has changed. So if you have a situation where a client's protected person, the potential ward, only sees a nurse practitioner or only sees a physician's assistant, you're going to need to ask your client to talk to the office. And a lot of times, if there is a supervising physician, an MD or a DO that works alongside the nurse practitioner or the physician's assistant, and they can sign the report together. It cannot just be a nurse practitioner or physician's assistant signing the report. If they are the only ones that are signing the report, the client needs to be aware that a supplemental report with the medical doctor may be needed. And if the protected person, the proposed ward, doesn't see a doctor regularly, then what I usually recommend is the client talk to the office that they do go to, see if there is a medical doctor or a DO there that they can meet with, or call their insurance company and get a referral. So there are ways of figuring it out. It can just, in some situations, take more work than others. But just know that an NP or a PAC is usually not sufficient enough to award guardianship. And then the medical report, in some situations, you have somebody who needs guardianship, but they're already driving or they want the ability to drive. That medical professional, it's going to be crucial for them, if it's appropriate, to provide in writing their opinion that this person can physically operate a vehicle. There's a little bit of information that is included in the medical report. It's very short, but if your client's very passionate about the protected person keeping the right to vote, the right to drive, then I usually ask for a self-standing medical note, doctor's note, to file. You can also have more than one doctor file a report in the matter. It doesn't need to be just one. So it's something that is helpful to a lot of individuals as far as their ability to have the protected person keep the privilege to drive. They can also take driving evaluations with different driving schools and things like that. Some individuals will take permit tests. So there are different things that can be filed and put onto record to support that there is a ability to drive at the time the orders are entered. If it's a situation where they want maybe their child to be able to have the potential to drive, or their loved one to be able to drive, they just can't do it right now, and the court says, nope, we're not going to give that privilege to this person at this time. When the situation changes and when that is supported by a medical professional, you can always ask for a modification or a conversion. We can go ahead and go to the next slide. Okay, so change in voting rights. So this has kind of gone back and forth for a while. You would have some judges indicating that if there was a general guardianship ordered, that voting rights would automatically be suspended. Others would not do that. And then there was a little bit of a change in that view. And then, generally speaking, most times when a general guardianship would be awarded, voting rights were automatically suspended. That has since changed in the last year. So prior, when guardianship was being ordered, there had to be clear and convincing evidence supported, just like with driving, that this person has the ability to vote. It would be on the shoulders of usually the guardian to either provide medical information or some sort of convincing evidence that this person who's protected does have the capacity to vote, and we want them to keep that. And in most cases, a limited guardianship would be needed. That's changed now. So with general guardianship, voting rights are not automatically suspended. In order to have them suspended, then you need to provide evidence that this person does not have the ability to vote, which realistically speaking, I don't know if that would be something that you'd see very often, but just know that driving privileges and voting rights are in separate categories. Driving is still looked at on a case-by-case basis, but generally speaking, voting rights will remain intact unless there's some sort of convincing evidence that this person absolutely cannot do this thing on their own. If there's ever a question and there's uncertainty on whether or not this person can vote and they still want to try to prepare for it, then they can complete a provisional ballot if the timing allows, and then let the court case run through as it needs to. But just know that there is going to be the change in voting rights. And I know that last time I checked, I don't think Maricopa County updated their petition to reflect different language, but Coconino County did. And you can view on their petition, it talks about very short and to the point, should this person have the right to vote, yes or no? And so it no longer allows or requests you to provide clear and convincing evidence that this person can do this thing at this time. We can go on to the next slide. Okay, so the health professionals report. This is going to be really important. A lot of times you can file just regular old medical records that the individual might have, the proposed ward might have in their record. But depending on the age of the record and how those records come through, sometimes it's just not enough to get guardianship. So there is a court form. It's a standard court form. It was recently updated. It will basically indicate from a medical perspective, what does this protected person, this proposed ward, have the capacity of doing? It's going to talk about driving, voting, if they should be living independently, if they should be living with family members, and it's going to make it very easy for the judge, the attorney, the investigator to view that information because they don't have to decipher medical records from an office that might look a lot different than what they're used to seeing. You can still file those medical records, but usually the way I do it, it's in support of the health professionals report. The court, the investigator, the attorney, they're going to be looking for that form. Like I mentioned before, a nurse practitioner or physician's assistant is no longer enough on its own to determine incapacity for an individual. It needs to be signed by an MD or a DO. And then if the person is needing inpatient mental health treatment, it should be a psychiatrist or a psychologist that completes that form. If it's not, if it's just a regular medical doctor or DO that doesn't have does not specialize in mental health, it could be problematic for your client. Usually when somebody has a request or a need for inpatient mental health, their loved one, their child or their family member already is established with a psychiatrist or a psychologist that has the credentials to complete the report. But what you may notice is there's a very large volume of psychiatric nurse practitioners, and they're great for care, but their license is not sufficient enough to complete that medical report. You have a lot of psychiatric nurse practitioners in places like CBI and Valleywise and other places which provide care. But when it comes to the report for inpatient mental health, it's not enough. So sometimes it's a little bit of a fight for your client at that facility to have a medical doctor sign the report. It's getting better as time goes on, but they staff so many psychiatric nurse practitioners there that it can be difficult to have a medical doctor sign the report. And although in Maricopa, it's not required to be filed in the beginning of the case, it's going to make it easier on your client. So usually, as soon as you get started, you want to give them the medical professionals report to start working on. So if there is a delay with getting it from their medical office, maybe the doctor's out of town, or they just take a long time getting paperwork together, or they have to come in for a meeting and they have to wait for a certain time or anything like that, you've already got that in process. You do not need a case number for the doctor to complete the report. If the medical report is filed in the beginning of the case, then when the investigator and when the attorney go to do their part, they already know that it's supported by a medical professional, and they can use that when they do their interview, when they do their investigation. So in Pinal, it's going to be required. In Maricopa, it's not required, but it's usually recommended, more so for the ease of your client. So they don't have the attorney and the investigator breathing down their neck, and yours, trying to get the medical report filed. Also, in the hearing set, the court is going to vet that medical report because they want the individual that's listed in the petition, the one signing the medical report. We can go to the next slide. Okay, so if you've been doing guardianships for a while and you have your documents set all ready together and you don't always go to the law library to pull your forms, you might have an outdated medical report that you're using. The courts are still accepting that, but there is an updated one, and I think it's more so to accommodate for voting and things like that. Generally the same form, a few changes, but if you're using your old form, you will want to go ahead and update that. We did go pretty in depth into the need for a psychiatric specialist to complete the report for inpatient mental health. Also, while I'm talking about it, the report needs to indicate if your client is needing to have the inpatient mental health treatment authority included in their order. The report needs to indicate that, yes, the proposed ward, the protected person, may need that treatment within the next year. And that treatment does expire. The guardianship does not expire every year, but inpatient mental health does. So we'll talk about that a little bit more towards the end. But if you have a client who is awarded the inpatient mental health authority for their loved one, not only do they just do the annual report, they're going to have to talk about the need to continue that ability to place them in an inpatient mental health facility. We can go to the next slide. The training. Training is super simple. I think the hardest thing is for your client is them finding the web page and not doing all of the videos. There are, I think, 5 or 6 videos available. It's the standard training for probate for unlicensed fiduciaries. It's going to be the same web page that people go to for personal representative training, for conservatorship training, for guardianship training, for all of that. So usually at the same time that they're doing the medical report, they're going to do their training as well. And the only videos that they are required to watch, it's the pending they're not doing conservatorship, it's the guardianship training, and it's the unlicensed fiduciary training. Those are going to be the 2 videos that are going to be needed. Sorry, the 2 training certificates that are going to be needed by the court. There is a certificate that will pop up at the end of the training video, and the certificate needs to be signed and dated and filed. So you'll have one that talks about non-licensed fiduciaries. You'll have one that talks about guardianship training. The court will not issue the letters unless those training certificates are completed. If there is a need for conservatorship and they're being awarded conservatorship, they also need to watch the training for the conservatorship as well. So that's not needed. The conservatorship is not needed unless it's actually something that the courts, you're asking the courts for, or the courts have ordered. Like the medical report, I like to get this done in the beginning of the case because the investigator and the attorney, they also want to see the case be processed as seemingly and quickly as possible. So they want to get things done for that finish line of the hearing. And they know that that training is a big requirement. So if it's done in the beginning of the case, it's going to be easier for your client. What I like to tell clients is there are no "Are you still watching" links. There's no test at the end. It's not like driving school. It's important. It's very informational, and it's information that they are going to need to be using as a tool for their roles as guardian or conservator, and just good background information. So just in case they move or there's an untimely death, they know what to do. The second training, well, you have your guardianship training. The second training, the unlicensed fiduciary training, that basically is talking about, as a guardian, you have a role and responsibility to act on behalf of somebody else in a legal capacity. That relationship is considered a fiduciary relationship. You're acting as guardian. Your client is acting in that person's best interest. So as if this person was doing things on their own independently. So it's not self-serving. It's not a self-serving role. And the fiduciary training essentially is talking about that. So just those two videos are needed. Takes less than an hour. There's no test. And then once those certificates are done, they can email them to you, or they can provide you the original. As many of you are probably aware, in Maricopa, they don't require original documents to be filed. So they can accept copies, either e-signatures or copies of signatures. So they can provide the certificate to you as the original, or a copy is sufficient. Pinal County is not that way. Pinal County wants originals of everything for the most part. So I usually get all originals of Pinal County. I know that there was at one point in a way of filing online, but I was never successful with it. So usually with Pinal County, I do things in person. Yes, Don.
No, I just wanted to comment that I really, I really like the fact that they have these videos, and these are similar videos. Well, one of them's the same that they use for probate as well, and I like them because I think it reinforces the responsibility that the client has to make sure these things get done. And it gives me an opportunity to distinguish between what I'm doing for them and what I'm not doing for them, and regardless, what they're ultimately responsible for. So there's not an overdependency on us as document preparers, for things that we really don't do, or can't do for them. And I don't know how much that relates to guardianship. I think it relates a lot with probate, matters.
Absolutely. I would say a little bit more so with probate, but with guardianship as well, because there, once the hearing date takes place, there's every year there's going to be stuff that they need to do to maintenance this guardianship, and it talks about that in the training. So it gives as document preparers, we're supposed to be providing our client with information about the process, but there is going to be information that is in that training that is a great tool for them to go back on, and they're signing a document saying that they've read or have heard the training. So it's a great tool and resource. And sometimes if I have clients that have questions after the hearing date takes place and they call me, I'll just direct them to the training and say, just watch the training video again. Some of these questions are answered. It might be a good review for you. So I couldn't agree with you more, Don.
There was a question in the chat from Michael, from Mike. Do you ever attend or dial in for hearings?
No, there's no need to. The hearing is, from what I've gathered, I can't say for Pinal County. I don't know how long the hearings are, but for Maricopa, it takes about 15 minutes. It's very procedural. The court is just making sure that all the departments have done their part. So the investigator has their report in, the medical doctor has their report in, the petition has all of the requirements and requests that are needed. And so there's no need for me to attend the hearing. I haven't had to. Mm-mm. Any other questions so far before I dig in? Okay. All right, we can go to the next slide. So we have file, set hearing, and provide notice. So when you file in Maricopa County, the clerk is going to be looking for this stuff minimally. They're going to be looking for the probate information form, and they're going to be looking for the probate cover sheet. I can't remember when. I think it was 3 years ago. The probate information form and the cover sheet used to be one document. They've split it into two. So the probate cover sheet is more about what's being filed and who the petitioners are and who the ward is. The probate information sheet is talking more about the who that individual is that's acting as guardian. It's going to give names, addresses, telephone numbers, dates of birth, social security numbers. I do know that depending on what kind of probate case you're filing, the clerk, or more so the registrar, so it's more for like informal probates, they want that whole probate information sheet completed. So you can't leave anything blank. They want it all completed. I usually use the same standard of practice for the guardianship case, pending with the protected person. You'll notice on page 2 of that probate information sheet, it's going to talk about, for the protected person, their height, weight, eye color, hair color, all of that stuff. For the protected person on the information sheet for guardianships, I usually just indicate the legal name, the address, if there's a phone number, their date of birth, and their social. As far as the identification information, it's not required, and the clerks don't ask for it. Also, because we're dealing with somebody who's potentially vulnerable, I don't know if it's necessarily appropriate to provide that unless the courts really need it. Now, for the guardians, I do provide that information. So you are asking for their height, weight, their eye color, their hair color, their social security, their date of birth, all of that information I typically disclose to the courts. And then if big things change, like they move or they get a new phone number, they need to update that information with the court. And there are different ways of doing that. There's an updated address or name change form, but you should also be filing an amended or an updated probate information form. So there's different documents that are proper to be filed when the information's updated. It's not usually just an updated address form. So we got the probate information sheet, we got the probate cover sheet. On the probate cover sheet, make sure you pay attention to, are you selecting guardian? Are you selecting guardian and conservator? Are you selecting inpatient mental health? Are you not selecting inpatient mental health? Because the box that's selected on that form is going to kind of dictate the path that the case goes through, and it's going to dictate what the courts are looking for when they do their part. Also, you have the opportunity to indicate whether or not a translator is needed. And let's say you forget that a certain case needs a translator and you don't put it on that form. When you go to set the hearing, you can still ask for a translator. The petition you'll file with the initial packet, of course. The affidavit of each person needs to be filed. The affidavit's just background information for each guardian. It talks about things like, have you been a felon before? Have you been nominated through a power of attorney before? Have you been removed as guardian before? Have you acted as a fiduciary for somebody before? Things like that. And then if the client has it ready, you want to file that medical report and you want to file the training certificate. We can go to the next slide. Okay. So once the case has been filed, at least in Maricopa, procedurally in Pinal, this is going to be significantly different. But in Maricopa, once the case has been filed, the documents need to be docketed. So unless you have your runner or you personally are filing the documents and you go to the probate administration office that same day, you're going to need to wait for those documents to be docketed. Sometimes it's a couple of days, sometimes it's a week. It just depends on how busy the docketing department is. But when probate court administration, you call them, they're going to pull up the case. They're going to confirm usually the petition that was filed, the date it was filed, if the child's 17 and a half, about to turn 18, or if they're already an adult. And the hearing, if you are in a situation where you're dealing with somebody who's a minor and you need the guardianship to be effective at the age of 18, if the documents were filed when they were around 17 years and 6 months, the hearing is probably going to be before the 18th birthday, which is usually what your client wants. That way, when they turn 18, the child just emancipates right into the guardian's care, and a lot of those services or the abilities for the parent or the loved one to assist continues, so there's not a lapse. If the child does turn 18 during the process, the case is usually unimpacted. So let's say they turn 18 in August and the hearing isn't until September. Well, there's no guardianship put in place for that interim. And if there's an emergency that arises, you can file for an emergency guardianship. Usually the child turning 18 is not considered an emergency, but depending on the circumstance, I guess it could be. But just know that you don't have to start over. You don't need to typically amend your petition or anything like that. The courts will just know, well, this person's already 18. Before, this has been like this for a few years, before when you set the hearing, you had to call Office of Public Defense Services to get a court-appointed attorney assigned. Now the division does it for you. So all you have to do is call probate court admin, get the hearing date set, and then the attorney and the investigator, they're going to be assigned by the division. Keep an eye on this. Make sure that it happens. It's a manual process. It's done by members of the court, and sometimes people get busy and things fall through the cracks. So it's your responsibility to make sure that the investigator and the attorney have been assigned to the case. The order appointing the attorney is going to be emailed to the petitioner. Sometimes they'll also email it to the document preparer. It just depends on how it was put into the system. And if there is an issue with the medical professional that's listed in the petition, you typically find out at this step. The most common thing is there's no medical designation for the medical professional that was listed. It's just a name. So the court doesn't know if it's an MD, it's a DO, it's a nurse practitioner, if it's a physician's assistant, or if it is an NP or PAC that's been listed. A lot of times the order itself will indicate that a doctor needs to be found so they can issue an order indicating that that doctor is supposed to complete the medical report. Again, a lot of this is alleviated if the medical report is done in the beginning. That way your client is on the same page as the doctor, and the information is already in the petition and everything's already filed. So it's a pretty big detail to the case to make sure that you really want the doctor listed in the petition to be the doctor that files completes the report. If there's a different doctor that completes the report than the one listed in the petition, a lot of times it's still fine as long as they have the right credentials. You don't necessarily have to amend your petition, but it's proper to do so. So it kind of shoots you in a bit of a gray area depending on the judge that you have. I like to make things as black and white as possible so there's no question for the client when they go to the hearing as far as why is this doctor listed in the petition and this doctor completing the report. If we amend the petition, well, the court usually knows, well, the petition was amended because this doctor now completed the report. But I can't say that it'll cause the hearing to be rescheduled if the doctor listed in the petition is not the doctor that completes the report, but it could. I'm sure it could. Okay, we can go on to the next slide. All right. Oh, there we are. So I talked about this a bit. Court-appointed counsel, they represent not the case, but the proposed ward's best interest. If everybody's in agreement, so mom and dad aren't fighting, a medical professional supports the guardianship case, there's no valid objection by the protected person or proposed ward, that court-appointed counsel, although very important, they're not doing a whole lot to the case, meaning that they're not actively working with these individuals on a daily or weekly basis. They're going to be doing their due diligence, making sure that everything that they need to do is done and that there's nothing left to question. They're going to look at things like before it was driving privileges and voting rights. They're probably still looking at those things, but voting rights in a little bit different perspective. But if somebody is asking to retain the privilege to drive, then they're going to be looking at the documentation that was submitted to support such. If mom and dad start fighting over who needs to be guardian, or if there's a valid objection by the protected person, that attorney's role is going to change significantly. And this is kind of that teetering edge of where it could become a contested guardianship if objections are starting to be filed. Our office does not deal with guardianship matters that have been contested. I usually recommend right in the very beginning of the case, if the client feels like there might be an objection that is going to be filed, they need to talk to the medical professional and see if this guardianship is supported by them. They can also talk to an attorney to see if the guardianship is contested, if it does become a bit of a fight, what they need to do, because there is that court-appointed attorney involved, and that protected person is going to have somebody there actively advocating for their rights. So, sometimes the information providing to the client is what you need to do. That way the client has in their wheelhouse the ability to find the resources that they need to in the event that this does happen. They've already done their due diligence. They already know, okay, if this becomes a fight, I know I can call this person to assist me. And they are also very also aware that that court-appointed attorney is not the attorney for the case. They're not assisting the guardians. They're assisting the person who's vulnerable in the matter. That's the proposed ward. The investigator, I always call them an interviewer because they are interviewing the parties. They are doing an investigation, but when people hear the term investigation, it's scary. They think that they've done something wrong. So the investigator is interviewing all the parties that are related to the case. They're talking to the guardians. They're talking to the protected person to the best of their extent. And they're going to create a report that the report is shared with the guardians, it's shared with the attorney, it's shared with the judge. It's a confidential filing, so it's not open to the public, but it is shared with the parties that are impacted. And the investigation can be done in person. It can be done over the phone. It can be done by FaceTime. It's really within the court's discretion or the investigator's discretion on how they want to organize that. Obviously, during COVID, a lot of it was done remotely. Now things are going back to be a little bit more in person, and they can even, if it's appropriate, go to, if the proposed ward or protected person is a minor, sometimes they'll even go to the school and do it there. All very straightforward stuff. They're not trying to trick anybody. Usually all of the questions that they're asking, the family is well aware of because they've proposed that information in the petition. This is where IEP stuff and medical records could come in handy. Those things are not normally filed in the matter unless there's a need for it. But those records that a family member might have for somebody who is about to be protected over guardianship, just have those available for the attorney, have those available for the investigator. The attorney is going to send out a list of the documents that they typically want to see. All the court stuff, us as document preparers will provide to the attorney, but anything outside of that, like estate plans and stuff like that, will likely be provided to the either the attorney or the investigator or both. We already talked about the deferral. It's super important, usually in most circumstances, that it is completed on the proposed ward's income. That way it gives that family a chance to have them waived. Not a requirement though. You don't have to file the deferral application. You don't have to complete it based off of the proposed ward's income, but it makes it a bit easier to get the fees waived. Oh, very important. If the guardian revokes their petition, they say, I don't want to be guardian anymore, or it's denied, the court say that guardianship isn't needed, or if the person moves out of county, the proposed ward moves out of county, the court will not waive any of the fees. And then the guardians are typically responsible for paying the attorney, the investigator, things like that. So the fees only have an opportunity or potential to be waived if the case finishes and if guardianship is needed. If the petition is revoked or if there's substantial asset like a conservatorship, then they're not normally waived. So never a guarantee with guardianship that the fees are waived, but pretty standard to the matter. We can go to the next slide. Providing notice. Okay, so this has got some good stuff to it. So the court-appointed attorney, you're going to give them a set of everything. A lot of times the court-appointed attorney has an ECR account and they can pull the documents, but as a courtesy, you want to provide them the full document set. This isn't going to include the medical professionals report and the probate information sheet because those are confidential. I don't think the attorney can pull them from ECR. So just give them a full set of everything that's been filed in the case. If the medical professionals report has not been filed in the beginning of the case and you've already notified the attorney, you're going to need to provide that document to the attorney once it is filed. So just keep that in mind. The investigator is notified by the division when the hearing's been set. So you don't have to give the investigator a full set of documents anymore. My understanding is that they don't want that hand delivered anymore because the investigator has the authority to pull all of those documents. So you don't need to worry about that. Now, any individuals that are entitled to notice, they just need the notice of hearing and the petition sent to them. So when we're looking at service and things like that, those are the two documents that are sent. So you're not sending out medical professionals reports or anything that has a social when you're sending out notice. We can go to the next slide. Okay, so most individuals can be notified by mail or hand delivery within reason. So there are certain individuals that need to be personally served, and depending on who they are, there are different methods that may or may not be appropriate for service. So the non-petitioning mother and father, so if you have mom or dad requesting to be guardian and one of the parents is not going to be guardian, then that non-petitioning parent can be served either with a process server or with an acceptance of service. Either will work. It doesn't need to be a process server. If the person is already an adult and they're married, same concept. They can either be served with a process server or an acceptance of service. So those are two methods of personal service that the courts will accept. They can also attend the hearing if they want. That can waive the requirement of notice, but it can make it a bit more stressful for your client because the attorney and the investigator, they're going to want to see that acceptance of service or that physical document indicating that they were given legal notice. Now, the proposed ward, the proposed protected person, they cannot sign anything because you've alleged in your documents that they're not of sound mind. That is the basis of the guardianship. That is the basis of the conservatorship. And when it comes down to the black and white process without any gray area, the only way to waive the requirement of them being served with a process server is to have them attend the hearing. However, that being said, if they attend the hearing and the judge cannot measure their level of attendance and the judge cannot waive the requirement of service, it could potentially impact that hearing, and it would then be rescheduled, allowing the petitioner time to serve the proposed ward. So if you don't serve the proposed ward with a process server, it kind of opens up a potential for the hearing to be rescheduled for multiple reasons because of the reason I just mentioned, or you might have a situation where that proposed protected person has a compromised immune system and they can't attend the day of the hearing. They're not feeling well. Well, the court will not proceed because they were not served. So to alleviate any potential issue, although it is an extra cost to your client, in most situations, I will recommend that they serve the protected person with a process server. It also allows a little bit of a surety that the person whose rights were impacted was given legal notice and an opportunity to object if they're of competence to do so. It also allows the attorney to know that their client was legally notified. Again, not at the end of the day, not a requirement, but definitely recommended because it makes that protected person's attendance optional at the hearing. And because the hearing is virtual, it only takes about 10 to 15 minutes. Sometimes it can be difficult during the hearing itself for the judge to measure whether or not this person understands or does not understand what's going on. Pinal County is a bit different because they are doing things in person. If you bring the protected person with you physically to the hearing, then that usually is enough to waive the step of being served, but not always. So in Pinal County, there's a little bit more of a leeway there to bring the individual with you to the hearing because it's in person, but service is always an option there. Let's see here. And then anybody that's not served personally will be listed on the proof of notice. And then we can go to the next slide. So there's been a little bit of a change when you're sending out notice to those that are entitled. At a minimum, one person outside of the family unit that's petitioning needs to be notified. So if mom and dad are both petitioning to be guardian and you have somebody who's a minor, or you have somebody who's an adult and all of the children are petitioning to be guardian, the next closest relative must be notified. And that's usually considered, depending on the circumstance and who's entitled, it's either going to be the spouse, it's either going to be the mom or dad that's not petitioning, it's going to be the adult siblings, or it's going to be like maternal or paternal grandparents. And if there are no maternal or paternal grandparents, maybe an aunt or uncle. And if there are truly no relatives associated with the protected person that are available, then you need to publish. So the court needs to see at least one person outside of the case being notified. If one parent's not petitioning and they sign an acceptance of service or they're served, that's sufficient. But in cases where mom and dad are petitioning together, usually the next closest relative is going to be considered the sibling or the siblings. Depending on the judge that you receive or the commissioner that you receive for your hearing, some judges or commissioners only want one sibling notified, that's sufficient. Some of them look at the scope laterally and they want all of the siblings to be to be given notice together. So what I typically do in most cases where it's appropriate, I will notify if mom and dad are both petitioning to be guardian, I will notify all of the siblings. And notifying all of the siblings, it's not personal service, so you don't need to serve them with a process server. They don't need to sign an acceptance of service. They are able to be notified by either hand delivery or certified mail. I've had the most success with certified mail. You can't just mail it regular, it's got to be considered certified. The green card does not need to be filed, but the proof of notice does need to indicate that it was mailed certified. That's been a change within the last year that the courts have wanted to see, not necessarily who's being entitled to notice, but how, when you are sending out documents by mail, how it's mailed, and they want to see it certified. If there are no relatives that are associated with the individual that's protected, then publication, I would say, would be the next step, just to make sure that there is something out there to attempt to give somebody notice. And the courts will make their rulings based off of the hearing to see if that's sufficient. And it's also important for the client. Let's say something happens to the guardianship. You want to make sure that somebody outside of that unit knows that that loved one has a guardianship put into place, and there may be a need to step up to have a successor filed in. So, and also in situations where maybe there's stuff going on behind closed doors that we don't always know about, well, let somebody in the family know. That way there is an opportunity for there to be an additional advocate for the proposed protective person. In guardianships, we're dealing with people that are vulnerable. Okay, we can go to the next slide. Hearing preparation. All right, so before there was just one order to guardian. Now there's an order to guardian and then a separate order to guardian for inpatient mental health treatment. So the second order, that supplemental order to guardian for inpatient psychiatric treatment, is only needed for petitions where you're proposing for your client to have inpatient mental health treatment over the proposed ward. So it doesn't need to be needed unless there's a serious mental illness involved. The order to guardian, the supplemental order to guardian if needed, and the order of appointment, those can all be provided to the judge's office. That's going to be what the judge needs to see. You don't have to provide a full set of documents to the judge's office anymore, just the proposed orders. And the letters go to the client. So the judge's office, the division, they're not doing anything with the letters. That's going to be your client's responsibility. The judge's office, the division, they want to see the order to guardian, the supplemental order, and the order of appointment. That's going to be what they're dealing with. The letters of appointment would be for the guardian, and that's going to be filed and issued through the clerk. So the judge will sign their orders. They'll create some sort of system for either the documents to be mailed to the guardian, or the guardian will pick them up. And then the guardian takes those certified documents that were created by the court and goes to the clerk's counter, and the clerk will review the orders and help the guardian or the individual get the letters filled out and completed and signed and issued and all of that. The court, for all intents and purposes, go ahead and go to the next slide for me. The judge's office, although they don't actively tell the client this or the guardian this, there is going to be a review of those letters by the judge's office in the background within usually a month or 2 months of the hearing date taking place. And if there's something wrong with those orders, maybe it's indicating the wrong date for inpatient mental health to expire, or there's something that is insufficient on the form, maybe talking about driving or voting, or there's a restriction that's missing, the judge's office will let the guardians know that they're not in compliance and ask them to refile the letter. The medical report, if it hasn't already been filed in the matter, your deadline is 5 days before the hearing. Sometimes it happens like that. Sometimes there's not much you can do, and it is filed right before the hearing. But you, as the document preparer, it's going to be, as soon as you get that document, you're going to need to make sure that it's filed. You're going to need to make sure that your client has a filed copy. You're going to need to get a copy to the judge's office. You're going to need to get a copy to the attorney, and then the investigator. Usually at that point, they've already done their report. There's not much you can do to get the medical report to them, but it'll be your responsibility to make sure that even though the client might have not gotten it to you in a timely manner, if you want them to be successful at the hearing and they are within that deadline, once it's filed, you need to make sure that everybody has a copy of it. The judge's office might reschedule the hearing if that medical report is not filed within 5 days of the hearing, and that's business days, of course. Or if the orders have not been provided to the judge's office. And the delivery can be done for guardianship. It can be done hand delivery or it can be emailed. So you can email the documents to the judge. You can hand deliver the documents to the judge. It's up to you how you want to do it. When you email the documents to the judge's office, there is a size requirement. So if the file is too big, if your PDF is too big, it'll get kicked back as undelivered. So just watch out for that. Sometimes when you scan documents and it is a large file, you'll have to compress the size. Slightly frustrating. So just make sure that when you do scan in that stuff, it's not too big of a file that the judge's office can't receive. We can go for the next slide. All right. So after the hearing, the court appointed the individuals, and the individuals are required to file their letters. Sometimes this is forgotten. So you just want to make sure that the individual knows, yes, the orders are important, but that letter is going to be what is the final dot of the I and cross of the T. They need to get that filed with the case, filed in the case in the matter. And we discussed the review after the fact, so the judge will review the case to make sure that those letters have been filed. In cases where inpatient mental health was ordered, so there's a serious mental illness, the person needs to have long-term psychiatric treatment, possibly within the next year, there's going to be an expiration date listed on that letter as far as when the inpatient mental health will expire. That if the inpatient mental health is renewed each year, the letters will need to be refiled reflecting the new expiration date of the inpatient mental health treatment and authority. If there's no inpatient mental health treatment that's been awarded, it's just not needed for that individual, then you do not have to renew the letters every year. If it's a situation where at the time inpatient mental health was needed, but now it's not needed and it's fine to be expired, in that situation, you don't need to renew the letters. The expiration date being listed on the original letter is fine. But if you're continuing inpatient mental health treatment and authority, then new letters will be issued as well. Let's say there's a case where the client didn't understand or forgot or had something come up in life where they did not file the letters. The court will mail them a notice letting them know that they're not in compliance around the time that they do that review. And if they continue to not comply with getting the letters filed, it's possible that the court will set a hearing in the matter. And if they don't if they don't attend the hearing, it's possible that the court will terminate the guardianship. So it's really important that those letters are filed. If there's a conservatorship that's appointed, then there might be additional things that will be needed for that conservatorship, talking about documents that'll be filed in the matter when the proper accounts have been opened up, or when letters of appointment have been recorded, things like that. So when you're dealing with a guardianship and conservatorship matter, just know that you're going to be preparing your client for, yes, the hearing itself, but steps to immediately take after the hearing. With guardianship, there's not as much paperwork involved after the fact. We can go to the next slide. Okay, so sometimes after the hearing has taken place, things will change in life. This is very common. The orders are permanent for permanent guardianship until further notice. But sometimes you'll have a situation where guardians are now older in life. Maybe mom and dad were guardians of an individual for a while, or there was a spouse that was a guardian for their husband or wife, or there's just a situation of somebody was guardian for a long time and now another family member is stepping in, maybe due to age or ability, or somebody's moving, whatever the situation may be. You can file to have a successor guardian added on, or a co-guardian added on. So if you've got a situation where current guardians want to be discharged and there's new guardians to be added on, you can do that. You can ask for a second guardian to be put into place, so there be co-guardians. So as life changes, that can be something that you ask for. There's also sometimes there's a need in what kind of order the proposed ward now needs. So usually with general guardianships, in the very beginning, we went through the scopes of decision making. It talks about marriage and education and training and living arrangements and medical. That all is umbrellaed under the general guardianship. Now, when you have limited guardianship, it is not that full scope. It is limited. So when you're a guardian and you only need certain scopes of decision making, that's going to be the limited guardianship. Sometimes there's a situation where somebody may not have had the ability to do any of those things, and the guardianship order that was obtained was a general guardianship. And life goes on and things change, and there might be certain things that this person can do for themselves, and the guardian wants to relinquish some control and give it back to the protected person. In that case, you can ask to have an amendment done, or a conversion done from a general guardianship to a limited guardianship, or vice versa. There might have been a situation where there was a limited guardianship that was obtained for initially, and this person is now losing the ability to do certain things, and the guardian needs to take on more responsibility. So you can ask for a change there. And then if a guardian passes, it's going to be proper for the remaining guardian or the successor guardian, depending on the circumstance, to file a notice of death with the court, so the court knows that there's been a change. There might be circumstances where, more so I've seen this with Social Security, not often, but if there are two individuals listed on the letter of appointment and one of the individuals has passed, the entity that the client, the guardian, is working with might want to see a new letter with just the actual guardian listed. So you might need to file a motion to amend the letters. And then if the ward or protected person passes, it's supposed to be within 10 days. Sometimes it's just not realistic because of the grieving process, but there should be a termination that's filed with the court terminating the guardianship. And that's a very straightforward process. It's pretty much scheduling the hearing, getting the petition filed, setting the hearing, and then the courts will terminate and discharge the guardian, and if needed, release funds. All right, we can go to the next slide. All right, annual report of guardian and conservator's account. So there's a lot of work that's done to get your client up until the hearing. Once the hearing takes place, they're going to get their letters filed in. This is where the training comes in handy, because there's going to be continued maintenance that your guardian needs to do with the guardianship. It's not a lot, but it's not a set it and forget it sort of concept. Your guardian and potentially conservator, they need to do an annual report, and that's going to be very simple. It's 4 to 5 pages. They don't have to go back to court. It's basically talking about, has anybody's phone number changed? Has anybody's living situation changed? Has there been a significant change in the ward's physical or mental health? Sometimes when the annual report is done, you'll find out that your client moved or they changed their name. And if that's the case, they may also need to do an updated address form and updated probate information form. So it's more good housekeeping for the case and making sure that you're doing your reporting with the court. If you fail to do your annual report, the courts have the ability to terminate the guardianship. So the courts don't remind the client. They will send basically a compliance note saying that you failed as the guardian to file your report by your due date. We're going to give you this date as a compliance period. And if you don't get it done by this date, then we might schedule a hearing in the matter. And if you don't attend the hearing, then the guardianship might be terminated. If the guardianship is terminated, you can basically your client has to start from scratch and file back into the case and ask to be guardian and explain what happened. But know that the annual report is not optional. It is something that is required to be done. And if your clients do not update their address and they don't do the annual report of guardian, they're not going to get any sort of reporting from the court. So it's important to, as they move or as they change their mailing address, to make sure that the court is notified with that. A lot of times people think that when they update it with the MVD, the court has access to that they're automatically notified. I think this is just a general assumption. So I usually make it a point, in addition to what the training offers, to let them know if you move, you need to make sure to update your address with the court, because this is going to be how they contact you. There are some situations where they may contact the individual by email, but mail is really important, as well as email. If whatever email address that the court has, the client wants to make sure to have continued access to that email. We already talked about it a little bit, but inpatient mental health treatment, if it was granted, in addition to the annual report of guardian, there's a motion that's going to be filed, and that motion is just going to say, hey, with an updated medical report that's supporting the need, just letting the court know I need to continue as guardian to make inpatient mental health treatment decisions for this individual. There's a possibility that they, because of their serious mental illness, they may need long-term care, longer than what regular physical health will allow and outpatient mental health will allow. And the courts will look at that motion. The attorney will stay assigned to the case for these situations. So any other case with the guardianship, as soon as the guardianship ends, that attorney is discharged, they withdraw from the case. In situations where there's inpatient mental health, the attorney will stay on the case. They'll remain on the case, and they'll be notified every year that it's renewed. The motions, you want to get them filed if your client knows that they're getting inpatient mental health treatment for their loved one and they're going to have to renew it. You want to be filing these motions a good 2.5, 3 months before the expiration date. There is a lot of stuff going through these judges' offices, and with that pending expiration date happening, if you don't file the motion quick enough, usually the expiration date will unfold, and it kind of opens up a situation where a potential emergency may arise because the authority to make decisions for this person's inpatient mental health has expired. And sometimes these things are on set and we don't have a reason as to why. And the court can take up to 60 days or longer to make a ruling on the motion. Although a very simple request, it can take time. Or there might be a situation where the medical report that was filed is lacking something and the courts don't immediately grant the motion and a new medical report needs to be filed. So if you have a client that is coming to you to renew their inpatient mental health and their annual report of guardian, you want to be pretty certain of that deadline that's coming up, that expiration that's coming up, and have a conversation of how long it could take for the orders to come back. Of course, you can always try to file things on an emergency basis if an emergency is arising, but procedurally for the general process, just give it as much time as you can. I would say usually 2.5 months, 3 months is about the time that I like to file for the request to renew those abilities for the next year. If you're a conservator also, then you will also need to, in most cases, do an annual accounting. So you will be required to send an annual account along with your report for guardian, if you're a guardian as well, to the court. Not always. If there's not substantial asset, then this might be waived, but it's pretty common. Okay, and I know it's a lot of information. We could go to the next slide. I know it's a lot of information that I just threw at you. If you have questions or if you need assistance, this is my email and this is the phone number to my office. You can contact me here. We do a really high volume of guardianships and some conservatorships, and we deal with testamentary guardianships. So if a loved one has passed and there's somebody with a special need or a minor child, we do stuff like that. Oh, and last thing I didn't mention, and then I'll open it up for questions. If the person is worried about a backup guardian, they can do their nomination in a last will and testament. So the court won't appoint a backup guardian, but the current guardian can put that in writing in their will. So All right, any questions?
There is a question in the queue, and then I'll go to David Hoyt, who has his hand up. So the question in the chat says, can you provide a resource for guardians to call for direction when encountering problems with entities refusing to accept the guardianship?
So depending on the circumstance, I usually recommend that they call the court-appointed attorney that was assigned to the individual. Sometimes they'll be able to provide information for that. Other than that, I would say generally speaking, they need to find just a probate attorney that deals with guardianships and get some legal advice as to what they can provide that entity in addition to the letter to get them to comply with it. But usually the court-appointed attorney is a good place to start.
Okay. David, you have some questions?
Yeah, just one. You kind of answered right there at the end, one of them about a guardian appointing in their will or nominating in their will who would take over as guardian for their child or their ward. But what if that parent was never appointed as a guardian? They never went through that process. They've been taken care of an adult person who's severely disabled. Can they still nominate in their will who they would want to take over guardianship if they never had guardianship themselves?
Yes, so my understanding is they would still, because their loved one, their child, and it doesn't necessarily need to be a child, it can be somebody that they're providing care for that they have the entitlement to be guardian for. They can put that nomination in their will, and pending, so if you have a situation where it's a child and it's mom and dad, when mom passes, well, dad is gonna take over. I can't guarantee that this will work for all situations, but generally speaking, as long as everybody's in agreement, the person who is acting as guardian, that will would then need to be probated and put onto record. And then what's called a testamentary guardianship would then be created, referencing the probate matter and referencing that will, because the will would be validated by the registrar. And so that will becomes the nomination for the person listed in the will to become guardian. So you would have to file a probate matter, and then you would have to file the guardianship.
Got it. Thank you. And what about to follow up? What if they did a separate nomination of guardian outside of the will as well? Would that still need to be probated?
What do you mean separate nomination? Just like a
So,
doc?
yeah, I've seen a separate document that typically we'll do it in the will for minor children, but then separately we'll do a form that just nominates a guardian. It's not a will; it's just a nomination. We throw that in too. I'm not sure in what situations that is acceptable as opposed to the full will.
I'm not sure. I've never seen that done.
Okay.
At worst case scenario, you try to use that to get the person appointed as guardian. And if it's not sufficient enough, the courts will deny the petition and usually let you know procedurally what needs to be done on whether or
Gotcha.
not that's going to be sufficient enough. That would be my thought process on it.
Okay. Perfect. Thank you very much.
You're welcome.
Okay, there's another question in the chat. How would you handle a situation when a medical report filed with the court was signed by a PA, not an MD? The hearing is upcoming in this case.
Oh, okay. So I would let the client know that there's a possibility that the hearing will be rescheduled because of the credentials of the doctor, or sorry, the physician's assistant that signed it. And then I would let them know, usually to accommodate that, take that medical professional's report back to the office and see if the supervising physician will also sign the form. So you'll have like an amended medical report, and it'll also have the signature of the medical professional there. Not always, because the laws recently changed, is my understanding, but usually when you have a PA or an NP signing a document, there's a supervising doctor there that has the proper credentials. Just have them too sign that same form. So the doctor doesn't need to complete their own form. They'll just sign it with the nurse practitioner or with the physician's assistant, usually.
Okay. Let's see. I have a couple questions myself. However, I do want to just kind of comment to the group that's out there. If this type of work is something that you're you have that you're considering getting into, um, please, while we're here today, ask some questions that might get you over that hump if if there are any issues there that you'd like answered. And so while you're thinking about that, a couple questions that I have. Um, what would you do? Well, first of all, what would you say is kind of the most challenging part of entering into that area? Was there any aspect of it that was particularly challenging, or on the flip side of that, is there something in particular that made it an easy transition?
I would say the most challenging thing getting started. Sometimes when document preparers start entering into a process or a field type or area of law, they're familiar because they've gone through a personal experience, so they have an idea of what their client's going to go through. I think getting into guardianships, it's probably more often than not that you haven't personally experienced this process. So just being very thorough on all the different steps and the procedures, as you do it more and more, you will get more comfortable with it. And uh, just have the time available so you can be double checking your steps as you're moving forward. And that way, if something does fall through the cracks, if there is something that needs to be looked at a little bit further or redone, you've given yourself enough time so you can manage your stress and manage the client situation at the same time, because it can be really stressful when you do something for the first time. It's a little nerve-wracking. You have a lot of responsibility on your shoulders to prepare for the hearing and make sure that your client's as successful as possible. So I usually read and I reread the process. I will be calling judges' offices and verifying that there has been no change in what's been listed on the law library as far as the procedural information. And I will be making sure that, to the best of my knowledge, I've done everything that has been listed in the law libraries for procedure, anything that's been recommended to me from the administration office, anything that's been recommended to me through the court-appointed attorney, anything that's been recommended to me through the division when I follow up and check to make sure. So just do what you know that you need to do as far as preparing the paperwork, but check and recheck the process to make sure that nothing's falling through the cracks. And also advocate to your client that there might be certain things that are beyond your control. The physician's report, the medical report is a really big one. Sometimes the client cannot get a medical doctor or a DO to complete the form. Well, okay, not ideal. And worst case scenario, the courts are going to reschedule the hearing to allow you more time to do that. So it's not like this requirement's going to go away, but sometimes we make up things when we don't know them. And being more informed is better than having there be surprises for your client.
Are the self-help center forms sufficient for a document preparer to get through that everything?
Initially, yes, but there are some things that the court has preference of that are not listed or that have changed. I think sending out notice for a while was a big one, where what the courts were requiring as far as like certified mail versus regular mail wasn't listed in the self-service forms, but it was the standard of what they were accepting at the time. Also, because there is that court-appointed attorney there, that court-appointed attorney is going to know what that judge's office is going to need. As a document preparer, you can call them and ask them, hi, I'm the document preparer that's assisting so-and-so to become guardian. Is there anything that your office needs at this point in time? And they'll let you know.
Okay, and then one more question, Laurentina, did you have a question? You're muted right now. Laurentia? Okay, I don't know if you don't have a question anymore, but you can't.
I don't.
You don't? Okay, all right. All right, and then there was, I guess we'll look one more thing in the chat, I think. I just want to make sure that oh no, just good information. All right. Well, Nicole, thank you so much. That was a terrific presentation. We really appreciate all the hard work that you put into that and all the knowledge you have about it. And Nicole has offered if anybody has any questions, communicate with her. I will be sending out her a PowerPoint along with the certificates of completion after we're done with the webinar. So, all right, without further ado, we're going to move forward. We're going to take a brief break, and then we'll come back. Actually, just before we take the brief break, I think everybody is still here. I am going to hold up the first verification word, and I'll share that. Give me just a second, and then we'll move on to Barry's presentation. But while we're setting up for Barry, but here, let's do the first verification word. So that word is, I can get it on there. I don't know what's going on. Okay. Oh, there we go. All right. So the first word is apple. APPLE, apple. Apple is the first verification word. Can everybody see that up there? I've shared it. I'll keep it raised. Apple is the first verification word. And then while you're looking at that, I'm going to, Barry, I know you're in there. There you are. I'm going to spotlight you so you can take over the meeting when you're ready. Okay. And Barry,
yes, sir.
Okay, so I've got the first word up. All right, everybody got that? I hope everybody has it. It's apple. And yes, some people are asking to take a quick break. Let's take just a quick 5-minute break, potty break. So, and then when we come back from that, Barry will be taking over, and I'll introduce him, and we'll go from there. Barry, do you have a PowerPoint that you want to share? If you want to, you're able to after I turn off my share.
I went ahead and I sent it to you.
Okay. Well, let me get. I know you did send it to me. Okay, so you'd like me to do the pages for you?
You're welcome to, or I'm not an expert at Teams, so.
No problem.
All right. I'll be back.
All right. Okay, we're going to get started in just a minute. I think I have Barry's presentation ready. All right, I think everybody is back from the break. So Barry, whenever you're ready, I think we'll be ready to get going.
Okay. Are we all here?
I think so.
Okay. All right. Good morning, everyone. I'm happy to be here once again. My name is Barry Goldman. Aside from being a legal document preparer in Arizona, I am a process server. I'm going on 38 years coming in May as a process server. I'm the administrator of the Arizona Process Servers Association. I teach process servers how to be process servers and also how to serve papers correctly. So, with that in mind, I also run my own education company for process servers. That's Accufax Publications, Accufax Publishing, excuse me. And I've got about 20 or so continuing education courses under my belt for process servers. One of the things that we go ahead and we have to do is, just like legal document preparers, we have to keep up with case law. We have to keep up with the new rules of court that change, statutes that change, the whole Megillah. So I'm just going to go ahead and cover a few things that have changed from 2024 to now, and some things that we'd like to see changed, and a couple things that we don't want to see changed. And we'll get into service of process as well, so that you can understand what the process server's mindset is when they're serving legal papers. So with that in mind, I'd just like to go ahead and tell you about small claims. Formerly, small claims could not be subserved. That is, going to the residence and giving the papers to another person who lives in the residence. That's what a subserve is. It's constructive service. It's not actual notice. There's two types of notice, and we'll get into that in the course. With the small claims formerly, we had to actually hand it to the person, and if that person wasn't there, then we'd have to go back and go back and go back. Now we have the ability to knock on the door. If, let's say, the husband is being sued or another occupant in the house is being sued in small claims court, then we can go ahead and we can leave it with that second person, and it's notice to the person being sued. Okay. So that's similar to what happens in a superior court civil case, okay, or even in a justice court civil case. Also, there's been a change in the justice court rules of court, which has not been posted yet on the Westlaw website. So if you're looking for it, it's not there. Subsection F of section 113 has been added to describe alternative means of service by electronic service. So that would be social media. That might be texting, it might be faxing, it might be any number of different things, so that the court can go ahead and assume that the person has received the papers. This is generally used for people who are avoiding service, that we don't necessarily have a good address, or the address is completely inaccessible, and they are active on social media. So one of the requirements is that the person has to have been in contact electronically between the parties um, within the last 60 days. So again, that's subsection F. It's in the handouts that you should be getting. Okay, so you'll have that as well.
Barry,
When
I'm
you,
sorry to interrupt, but am I keeping up with your, is this on the PowerPoint on
oh,
particular
no.
slides?
Don't even start the PowerPoint yet.
Oh,
Sorry.
okay. All right. No,
Yeah.
go ahead. Sorry to interrupt.
Okay. I'm just going over what's changed and what's changing. Then we've got ACJA section 1-901 has been initiated, and that mandates electronic filing. Mandates electronic filing by attorneys. It does not mandate electronic filing by LDPs or pro pers, but in some cases it may be preferable, and it will allow electronic filing. So that's something that came into effect in January as well. What's proposed in 2025? The Arizona Process Servers Association has noticed a trend that we are serving limited liability companies, and the process server is either serving them to the antiquated court rule, which says that the paper shall be served on a statutory agent or other person authorized to accept. But yet, the legislature passed the Limited Liability Company Act in 2019, and the court has not kept up with the statutes. So what we've proposed is changes to the rules to allow service of process to limited liability companies per ARS 29-3119, which is part of the Limited Liability Company Act, and it allows for multiple methods of serving a limited liability company. Because what we're finding is we're serving individuals who form an LLC, but who are hiding behind the LLC as an asset protection device. So that will allow us to go ahead and serve not only the statutory agent, but a person in charge of their place of mailing, such as a UPS store, because we get a lot of those people who use a LLC and they only disclose the UPS store address. So it will allow, because that is a place of business, us to go ahead and give to the person in charge. Or let's say a rent a suite where they're getting mail and it's occupied by a receptionist, and the receptionist says, okay, yeah, they're here today, they're not here today, that kind of thing. We can go ahead and we can serve that receptionist. Or any other means of service, which would basically be alternative means of service, but we don't need an order for that alternative means of service any longer. That's according to the statute. We can also serve by Federal Express, which is much different than when we're serving a corporation. We can't serve them by Federal Express. We have to go ahead and jump through the hoops before we can get an alternative means of service order. 29-3119 negates all that. It bypasses the alternative means of service order, and it gives us the ability to go ahead and easily serve an LLC. Unfortunately, there are certain judges in Superior Court as well as Justice Court who are going by the rules of court. They're not going by the statute. So even though the process server has served the LLC by statute, the judge is bouncing the service and saying, you've got to serve it by the rule of court. Well, that's wrong. The statute came after the rule of court, and the statute is legislatively passed. So the rule of court has to follow that, has to follow the law. Unfortunately, the rules of court don't necessarily follow the law in this case. So we're seeking to correct that. We would not expect a ruling from the Supreme Court until August. Hopefully, the state bar will not oppose it, because what we found historically is anytime the state bar opposes a motion for a rule change, that rule change is dead. So that's where we're at there. Then Senate Bill 1183. This is by Senator Ortiz, which we believe is a bad bill. Mandates that the process server take a photograph when serving a eviction paper, and we're posting and mailing, and then electronically transmit that directly to the court. Well, unfortunately, the courts don't take electronic transmissions directly from process servers. So that in itself doesn't work. Additionally, the senator is mixing apples and oranges. You have two different kinds of evictions. You have special detainers, which is the majority of evictions, where people don't pay the rent, let's say, or there's a health and safety code violation. In that case, within a certain period of time, we can post and mail the summons and complaint to the defendant. And that's a service that's done, as long as there's enough time between the posting and mailing and the hearing date. The other kind of service is a forcible detainer, which we cannot post and mail. We have to personally or subserve that paper in the same manner that we have to serve a superior court civil summons. If we cannot go ahead and get that individual served personally, we have to ask for, or I should say the client has to ask for, a alternative means of service order. In that case, the judge will simply order that the papers be posted and mailed. Okay, so you've got one where you've got posting and mailing is built in, and the other one where you can't post and mail without an order. But they're two different kinds of evictions. The senator, unfortunately, doesn't know her stuff and has mixed up a whole lot of stuff. The other issue that we've got with it, it's just an unworkable situation. Okay, not every picture or not every camera will take an embedded date and time on the picture itself, and that's one of the requirements in this bill. So the Process Servers Association is opposing this bill. Let's see. And that's pretty much what's new for 2025. So, Don,
I
are
am
we
here.
there?
I am here.
Okay, let's go to the next slide.
Okay.
All right, so I don't give legal advice. I don't think any of you give legal advice, and I don't give psychological or tax accounting or anything like that. So if you need any, seek a qualified professional. Next. All right, who can serve legal papers in Arizona? There are three parties who can serve legal papers in Arizona. Don? Generally, service process must be done by the sheriff, the sheriff's deputy, a constable's deputy, or a private process server. The private process server is the most efficient way to go ahead and get your papers served. They may not be the most cost effective for you, but they are the most efficient. In other words, my constable, he starts at $40 plus whatever for mileage. Myself, when I'm serving in this area, I don't set foot outside of my house for less than $100. So you may want to go ahead and spend money on the constable, but you end up getting a private process server because a private process server can go ahead and do the work in about 1/10 the time that the constable or the sheriff can. Now, that being said, we all have the same authority to serve papers. The sheriff's deputy, the constable, and the constable's deputy can execute an order. In other words, when you have a court order that says take property or take persons, they can go ahead and they can do that because they're peace officers. When we have an order, it's an order to, let's say, appear. It's an order to answer. So what we're doing is, as a process server, we're giving notice to people. We're not taking things. And that's a big difference between what the sheriff and the constable can do and what the process server can do. Next slide. And in Arizona, process servers are regulated. So not every state regulates process servers. You go to some states and they may post a bond and say, whoopee, you're a process server, like California. I was a California process server for a long time, and I had to self-educate. I had to self-regulate. I had to go ahead and uphold my own ethics standards. Okay, California doesn't have the kind of regulation that we have. Other states don't have the kind of regulation that we have. Some states, process servers are regulated under private investigators, such as Nevada, Illinois, and some other states. Other states like Florida, the process servers are handpicked by the sheriff in the county and then the judge in that particular district. So it's a complicated process in Florida. It's a complicated process in Illinois, Nevada, and especially here in Arizona. So what we do to be a process server is you apply at the clerk of the court, you take a test, you submit to a background check, including fingerprints, and then everything gets reviewed by the presiding judge. Once the presiding judge reviews everything, says everything's okay, then you are appointed as a process server. Every 3 years, we renew. So every 3 years, I've got to go the same rigmarole again. Okay. Right now, there are about 400 to 450 certified process servers in Arizona. None of us are licensed. We're all certified by the Superior Court as a process server. There's a difference between licensing and certification. Private investigators are licensed. Process servers are certified. Okay. The number of process servers has shrunk since COVID. If I'm not mistaken, it was up to a peak of about 1,150 process servers before COVID. So 400 to 450 certified process servers in Arizona keeps us quite busy. Okay. Next slide, please. Okay. We are regulated like legal document preparers are under the Arizona Code of Judicial Administration. Our code section is 7-204. We're also regulated under Arizona Revised Statutes 12-3301, which gives process servers the authority to serve papers. And the rules of civil procedure of the Superior Court, Rule 4D and 4E, says who can serve papers in Arizona: the process server, the sheriff, and the constable. Now, a word of warning. If you're sending papers to the constable and they're from Superior Court, the only kind of paper the constable can serve from Superior Court is a summons in a divorce matter. That's it. They have no authority to serve a regular lawsuit, anything else from the Superior Court. They have no authority to do that. Okay? We find constables exceeding that authority, and they're in effect acting as a process server. Part of their statute prohibits them to act as a process server. Process servers can serve any papers. Constables can only serve papers from the Justice Court or that one type of paper from the Superior Court. Likewise, the Sheriff's Department. The sheriff can only serve papers from the Superior Court. The exception to this is the municipal police serving a protective order from their municipal court. They can go ahead and they can serve those kind of papers. And that's it. They can't serve anything outside of their jurisdiction. So just a word. Okay. Don, next, please. Okay. Again, this goes back to 12-3301. Process servers may serve all process, writs, orders, pleadings, or papers that are required by law to be served before, during, or independently of a court action. In other words, we serve collection notices, we serve 5-day notices, we serve all kinds of other notices before the institution of any litigation as well. We cannot serve writs or orders requiring the service officer, such as the sheriff or the constable, to sell, deliver, or take into that officer's custody persons or property. And we are an officer of the court. The sheriff or the constable is not an officer of the court. They are a peace officer. Attorneys are officers of the court. Process servers are officers of the court. Okay. And then, of course, you have the judicial officer, which is the judge. Okay. Next, please. All right. So going back to an officer of the court, I hear process servers introducing themselves as, I'm an officer of the court. Well, being an officer of the court is not a noun, it's an adjective. It's a descriptive set of words. It's not a position. The officer of the court doesn't have any privileges or additional powers, but is a person who is mandated to perform within certain standards. They always have to exercise candor, just like an attorney always has to tell his client the truth. We have to tell the court the truth. We have to tell our client the truth. We can't hold anything back, whether the information is good, bad, or indifferent. We have to go ahead and let our client know what's going on with their paper. Was it served? How was it served? Anything like that. Now, what we cannot do is we cannot go ahead and report on the reputation or habits of a person that we are looking for, or the neighbors, or anything like that, because that's acting as a private investigator. So there's a few other quirks of what we can and can't tell a client. So an officer of the court has an ethical duty to go ahead and tell judges and their clients the truth, avoiding dishonesty and evasion. Any questions? Okay, next slide. Fees. Some of you may go ahead and have a good deal with your process server. That's wonderful. Okay. I'm a concierge process server. I charge a higher fee than your $40 process server does. The reason I do that is because I put a lot more work into my papers and I don't get as much volume, which I'm happy about, that other process servers do. So you may find a process server charging you $40 and another one may charge you $85 or something like that, depending on their level of service to you. What they give is what you're paying for. You may not see it, in the whole scheme of things, but that's what you're getting. Is you want to get as much value for your dollar. So in other words, if I get a paper from a client that says the defendant lives at 123 Main Street, first thing I'm going to look up is 123 Main Street a real address? Who owns the property? Do a quick background check on that defendant, okay, to know if that defendant is still at 123 Main Street, or if that's an address that's 4 or 5 years old, which oftentimes I'm getting, especially from large law firms, 4 and 5 years old addresses. So I want to be able to go in with as much information as possible and then report that back to my client. So whatever you deal with your process server, it's up to you to go ahead and negotiate your fee and pay the fee. So process servers are not regulated as far as fees go, like the sheriff or the constable is. They have a maximum that they can charge for certain services. Process servers don't. Okay, Don? All right, let's talk about making proper service. And if you have any questions, please go ahead and hit the chat, raise your hand, do whatever you got to do. I'll be happy to answer any questions you may have. Let's go. Next slide. I shouldn't have had all that caffeine, huh? All right, so we got 3 elements that make good service: proximity, notice, and identification. Next slide, please, Don. Proximity. Okay. The process server has to be within what's called easy speaking distance. Now, it doesn't mean that I have to be up close and personal with you. I could be across the street as long as you can hear me, I can hear you, you can recognize me, I recognize you, okay? And I show you the papers, okay? That's proximity. I've gone ahead and I've served people from that kind of a distance, and it's been upheld as a valid serve. I've also served people where they've driven away and I've left the papers there on their doorstep. Okay. That's perfectly fine. Once I'm giving you the papers, they're yours. They're not mine. I don't want them anymore. So easy speaking distance was a term of phrase captured in a California case called In re Ball. And it ensures that the person being served is within a range so the other components of service are given and understood. This could be within arm's reach of a person across the driveway, just so long as the process server and the individual can verbally and visually communicate with each other. Next slide, please, Don. Okay. Identification. Here in Arizona, I have to tell you, I'm a process server and I'm serving you with legal papers. Other states come up to you with a FedEx hat, the FedEx jacket, and carrying a package and tell you, hi, I've got a delivery for you. Or, hi, I'm from FedEx. We can't do that. That's a ruse. Okay. So what we have to do is we have to identify ourselves to you. Hi, I'm Barry. I'm a process server. I've got some legal papers for you. And likewise, I have to understand that you are the person that I am serving. So the process server must be able to get positive identification of the person being served. Likewise, the process server must advise the person that he or she is a process server there to serve legal papers on that person. We don't need your driver's license. We don't need your passport. We don't need, the next door neighbor verifying it's you, nothing like that, so long as we can reasonably assume that you are the person that is the defendant or the witness being served. Okay. Next slide, please. Notice. This is the third element, which is very crucial. We have to notify the person and they have to know that they are being served. So when I'm walking up to a house, I have to go ahead and hold the papers in plain sight. I can't put them in a pizza box, a rose box, or nothing like that. I can't whip them out and say, here you go. Nothing like that. I can't give them to you in an envelope. I can't cover them up. I have to give them to you as legal papers. You have to know the importance of these documents. Okay? We can't use any ruses, disguises, or deception to make service. It's against our rules, our regulations in ACJA 7-204. Next slide, please, Don. And when we contact defendants, when we contact witnesses, they can't refuse to accept service. Okay? Again, going back to In re Ball, and I'll quote this, We take it that when men are within easy speaking distance of each other and facts occur that would convince a reasonable man that personal service of a legal document is being attempted, service cannot be avoided by denying service and moving away without consenting to take the document in hand. Now, the language, this is from 1934. Today, the use of the word min or man would be person. Okay, so we can't go ahead and a person can't cannot go ahead and deny that they're being served. As to Michelle, no, I am not the District 1 supervisor. Thank you. Next. And again, this goes back to notice. The person must know that they are being served. We don't try to hide or conceal the legal papers we're serving. Serving papers requires the documents to be visible to the party being served. The papers must be open and notorious. And I'm not talking notorious in a bad sense. I'm talking notorious in I note the importance of it. The person must know that they are being served. There is a an Arizona case called Tonelson versus Haynes. In order for there to be a leaving with a copy of the summons and complaint as required by rule, such person must be aware of the leaving. This came out when a doctor's wife was contacted by the process server. The process server allegedly never said to the doctor's wife, I'm here to serve your husband with legal papers and I'm leaving the papers with you. Instead, the process server just left them at the doorstep. The ruling this came out of stated that she did not know that her husband was being served with legal papers. Because of that, the service was invalid. Okay. Next, please. Okay. So when we are serving papers, we are giving notice. There are two kinds of notice in Arizona: actual notice and constructive notice. In fact, there's two types of notice that are universal to every jurisdiction. Next, please. Okay. Actual notice is personal service. I'm giving the paper to you. You are personally served. This would be extremely important and vital when papers need to be personally served upon a person, such as divorce papers. Why? Because you have the preliminary injunction in there. Preliminary injunction requires personal service, even though the summons does not. Okay. Protective orders. Protective orders are punishable by arrest. You have to have personal service on there. Okay. There are some other things, such as a subpoena. Subpoenas always require personal service. The difference between a subpoena for deposition or appearance and a subpoena for ducis tecum, production of documents, is that the custodian of records doesn't necessarily have to testify with getting served with the subpoena ducis tecum. They can go ahead and they can provide the documents, and essentially they are still making the appearance. Then you have constructive notice. Constructive notice is a legal fiction. It includes substitute service, alternative means of service, posting and mailing, service by publication, and electronic service. In each of these instances, you're depending upon a third party or third wheel to go ahead and give notice to the person. Next, please. Okay. So giving actual notice is notice that is given directly to a party or is personally received by a party informing them of a case that could affect their interests. That's personal service. Now, the other way to go ahead and know that you've given actual notice to a person is they sign a waiver that they don't need a process server or sheriff to come over and serve papers upon them, that they've returned a waiver to the court. Next, please. Personal service does not necessarily mean the person must touch the papers. In-hand delivery in Arizona is not mandated. In other states, maybe New York, if I'm not mistaken, you've got to go ahead and you've got to touch the person. Well, not in Arizona. It might be considered assault. Okay. So courts have generally agreed that informing the defendant of the nature of the papers, offering them to the defendant, and leaving them within the defendant's physical control ought to and does suffice delivery. In other words, if you don't want to take the papers in hand, that's your problem. It's your business. But I am leaving them right here with you in your space. Next, please. Again, some people refuse to take the documents in hand. Once they've been informed of the service, presented with the documents, and been informed that they are being served, the documents may be left in their personal space without getting touched. Next, please. Okay. Again, certain documents must be personally served without exception. Preliminary injunctions, protective orders, orders to appear, and subpoenas. Next. All right. So again, constructive notice, it's a legal fiction. We're depending on that third person who receives the papers to act as the messenger. That's what this essentially is. That's a substituted service, and that's what constructive service is in all instances. You're depending on a third party to go ahead and deliver the message. Next. Okay. Service of a summons and other documents being served may be made on the defendant or the respondent or other person to serve by leaving a copy at their place of abode with a person of suitable age and discretion who resides there, or by delivering a copy of each to an agent authorized by appointment or by law to receive service. So when we're making substitute service, if I have a summons and complaint that I'm going out, knocking on your door, and you're not home, but your 17-year-old teenager is home, I can leave the papers with your 17-year-old teenager. Okay? It has to be done at a residence. It cannot be done at a place of business. If we are going ahead and making a substitute service at a place of business, it has to be by court order. Now, certain jurisdictions, I'll give you California again. California, substitute service can be made either at the residence or at the place of business, or at a UPS store. Arizona can't do that without a court order. It's alternative means of service. Next, please. Okay, so we've gone ahead. Yeah, constructive notice in Arizona is perfected by substitute service of the legal process when performed by a process server. In other instances, constructive notice may be given by a party by posting and mailing or service by publication. And in instances where alternative means of service are granted, the courts accept this type of service upon a party when service has proved impracticable, not impossible, but impracticable, especially in situations where the party is evading service. Next, please. Okay. So the methods that we commonly use in Arizona and pretty much everywhere else too: personal service, substituted service, alternative means of service, Posting and mailing. Now in Arizona, posting and mailing is used for evictions, but special detainers only, not forcible detainers. Service by publication and electronic service. And under the Arizona long arm statute, service of process may be performed anywhere within Arizona and throughout the U.S. Next, please. Okay. So when we're going ahead and we're looking up the rules to follow, the rules of court are I think there's 40 different rule books. 14 of them have service of process rules in there. Rules of family law procedure, justice court, rules for eviction action, rules for civil cases in superior court, and others have regulations or rules pertaining to service of process. The process server may go ahead and serve one type of paper one way, another type of paper another way, and they could be on the same party in the same case. It's just a jumbled kind of mix. One of the things that we're trying to do at the Arizona Process Servers Association is consolidate all those rules, and we'll go ahead and propose that to the Supreme Court as a consolidated rule book to go ahead and say, hey, all these different rules in these different books, this judge knows that judge knows that, but let's go ahead and just make all one service of process set of rules. So that's one of our goals. So let's go to the next slide, please. Okay. Again, personal service is done by delivering the papers to that person personally, and if it has to be a corporation, to the statutory agent. That's a personal service on the corporation. Handing the documents to the person, alternatively, leaving the documents in the presence of the person who refuses to accept service. And that may be called drop service. Process server never wants to go ahead and say drop service on his proof of service. As an LDP, if you look at a proof of service and it says drop served, reject it, send it back to the process server and say, eliminate that word drop served because it was personal service. You left it at their feet because they refused to take it in hand. Make some sort of a note to that, Mr. Process Server or Miss Process Server. Next, please. Again, the statutory agent can be served. A guardian ad litem is not a statutory agent, and they cannot accept papers on behalf of a protected person. So preliminary injunctions, protective orders, and orders to appear all require personal service. They cannot be given to agent, for service. Next, please. Subservice. Again, it's not done at a business. It's done at a residence. A place of abode can be described as a tent, camper, campsite, car, van, motorhome, house, apartment, back porch, condominium, couch, cave, hotel room, wherever that person lays their head. That would be the place of abode for that person. Next, please. Yeah. There's a phrase called suitable age and discretion. Suitable age and discretion is kind of a nebulous term. The Process Servers Association, a couple of years ago, we attempted to go ahead and change the rule for a definite, rock solid definition of what suitable age and discretion is. It was rejected by the State Bar Association, so we kind of gave up on that. We withdrew that petition. But just for reference purposes, suitable age is referenced in ARCP 4.1E and RFLP 4.1E. Okay, that's Rules of Family Law Procedure and Arizona Rules of Civil Procedure. 16 years or older is considered suitable age for serving a minor. Okay, when you've got a minor who is 15 years of age or younger, the parent or guardian has to be served. Okay, next, please. And let's go back to drop service. Okay, we hear the term drop service and it conjures up several things. For judges, it's a bad concept. It's an invalid form of service. For others, the term is ignored. Drop service may be a misleading term that in some instances a judge will interpret incorrectly, assuming the person who is being served is unaware that they were being served with legal papers. In other words, before they had gone ahead and been served or been told they were served, they were walking away. Okay, so that's why we don't want the term drop served used. Next, please. Next. There we go. As an industry practice, the term drop serve is frequently used within our industry to describe personal service when a party who has declined to take the papers in hand. But as a matter of practice, we don't put it on the proofs of service. But like I said, if you as the LDP see the proof of service from your process server and they have used the term drop service, reject the proof of service, ask them to do it over, and make a notation of the circumstances that the papers were served, by. Next, please. So, in all circumstances, it's not another type of service. It's merely descriptive of the situation where the person has refused to take their papers in hand. Next. Okay. Again, it requires proximity, notice, identification. Next, please. Okay. Let's talk about alternative means of service. This is something that maybe you may get into with your client because the process server wasn't able to go ahead and personally serve the papers or substitute serve the papers, which is fine. Okay. Alternative means of service is used in family law, it's used in justice court, it's used in civil cases, and that's about it. It is not used in small claims, not at all. Okay, next, please. It's the standard of impracticability, not impossibility. It's essentially performance that is excessively difficult, expensive, or harmful by an unforeseen contingency. It is not to be impossible or unreasonable. Next, please. The process gets started by a motion to the court, and it's a very simple motion. The server's certification of due diligence is attached, and that, accompanied by the motion and the proposed order, will go ahead and give the judge leeway to issue the order. Next, please. Okay. If the court allows an alternative means of service, the serving party must make a reasonable effort to provide the person being served with actual notice of the action's commencement. In other words, I've got to go ahead and knock on the door a couple of times. However, if a situation occurs where I've got a fenced property that says no trespassing, trespassers shot on site or something like that, I'm not going in. I'm just going to take a couple of pictures and skedaddle, and then give a certification to my client. Most of the time, the serving party must mail the summons, the pleading being served, in other words, the complaint, and any court order authorizing an alternative means of service to the last known business or residential address of the person being served, in addition to other means order, which is usually taking the papers that are being served and posting them onto the property, either taping them to the front door or attaching them to a fence bordering the property or something like that. Next, please. In situations where the person doesn't reside at the given address or the person doesn't work there, alternative means of service is completely inappropriate. And I've seen mostly collection agencies that want to use alternative means of service, when they can't go ahead and serve a person because the house is vacant. He can't do it. We don't serve vacant property. We serve people. Okay. These are some situations. We've tried 3 places at their place of work, but each time we were told by security that we could not enter the employees only area. And so we couldn't serve the person. The process server tried to serve the defendant at home, but the guard gate wouldn't let us through. Or the guard at the HOA gate wouldn't let us through. Or it was a closed gate all the time, and we couldn't get it. So, next, please. Okay. Person is actively avoiding service, but the address is good. Happens all the time. We've gone ahead and made database searches. We've talked to the neighbors. Yeah, the address is good, blah, 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 but nobody's answering the door. Another thing that we run into is the Ring doorbell and other video doorbells. When we come up in those situations, we make note of it. Okay. The other situation that I have occasionally come up with is person wants a stakeout. Well, the stakeout's going to cost you, let's say, $700, but you're only suing for $300 on a small claims case. It's not worth it to you. So in that case, the person has to go ahead and elevate it to a civil case and do whatever they got to do there. So, and there could be more reasons. Next, please. Okay. So let's go and let's cover eviction actions before my time gets run out here. Again, there are 2 types of eviction actions in Arizona. One is a special detainer. It's served under ARS 33-1377. These are usually for past due rent, health and safety violations, or some other similar circumstances that are set forth in the statute under ARS 33-1368. A forcible detainer is an action in which the occupancy or ownership of the premises are disputed. These would be squatters, trespassers, tenants of former tenants, foreclosed former owners of the residential property, and all commercial evictions, including if they were past due on rent. Now, interestingly, under commercial evictions, the landlord does not have to institute a litigation action. They do not have to institute an eviction action in order to go ahead and evict their tenant. They simply go ahead and lock out the person. There's a procedure for it. It's set in statute, and we're not going to cover it here, but that's what a landlord can do on a commercial property. Generally speaking, when I'm serving a forcible detainer, it's because the person who used to own the house is getting evicted from that property, and the new owner wants them out. Next, please. Okay. Posting and mailing. This is used in residential evictions. Prior to the eviction action being filed, the 5-day notice or other applicable notice is posted and mailed or personally served. And that's under 33-1313. 33-1313 governs how people know something has happened. Next, please. Okay. And there you can read the statute. It's in the handout that you're getting if you want to go ahead and read it. It also states that if a person has been mailed notice that they are going ahead and given an extra 5 days on that notice. Okay, next, please. Okay. 33-1377, the posting and mailing must be within the statutory window on a special detainer. In other words, 6 to 7 days prior to the hearing. Oftentimes, the court clerks are not going ahead and giving enough time to serve by posting and mailing, and the process server is mandated to make personal or substituted service. And I can tell you, in 9 out of 10 cases, people who are being evicted do not answer the door. Okay, posting and mailing for a special detainer action just is not used in forcible detainer actions. They are done by um, uh, alternative means of service only, if it's posting and mailing there. Next, please. Service by publication is kind of the last resort of service. It requires skip tracing by a process server or private investigator. It's only used when there is no current address for the defendant known, and it's not giving actual notice, and it will only go ahead and adjudicate in rem. In other words, property matters. It will not adjudicate other matters of, let's say, personal behavior. Stay away, do this, do that, child custody, that kind of thing. It won't do that. Next, please. Electronic service. Again, this is new in the Justice Court rules. It's Rule F, but again, Westlaw has not picked it up yet, but the order was issued on August 22nd, 2024, effective January 1st, allowing service by electronic means in a Justice Court civil case, not a small claims. Next, please. Okay. Again, this is new. Justice Court Rule 113F, like service by publication, it's a last resort. It can include delivery to an email address or to any other electronic method or service, provided that such delivery is reasonably calculated to ensure the defendant actually receives the summons and complaint. It's used for a defendant having a large social media presence and a residential or business address cannot be located, or serving there is impracticable due to a location or other reason. This also requires skip tracing by a process server or private investigator, so it's not just going to be willy-nilly issued. Next, please. Okay. Again, rules of small claims procedure. Rule 5B2 has been amended as of January 1st so that a small claim summons and complaint may be subserved at a residence address. Again, has to be a person who also lives there as well. What we're going to be doing is modifying that, or in our rule change proposal in 2025, to eliminate the word residence and use the term abode, because a residence is different than an abode. Okay. Next, please. ACJA 1-901 became effective. Authorizes and establishes the requirements for e-filing in the Superior Justice and Municipal Courts in Arizona. It's mandatory for attorneys and legal paraprofessionals as in Attachment A. Non-attorneys other than legal paraprofessionals are permitted but not required to e-file any document for which e-filing is authorized. And next, and this is our rule change petition, service to limited liability companies. Again, we've been serving limited liability companies, but there's a rule that has old language, and the 2019 statute says one thing, the rules say something else, so we've got to go ahead and we've got to make sure that they are in sync. So that's it, folks. Any questions?
A lot of information in a short period of time, Barry. You did a great job. Any questions out there? I actually am curious about the electronic service. Do you happen to know, has that been adopted by other states um, or is that kind of unique to Arizona?
It's kind of it's being adopted by other states, and I couldn't tell you which ones. I know Florida had some issues with it, and California, of course, uh, and I think Illinois.
Okay, you do have a couple questions. Let's see. Let's start off with Eliza or Elise. Eliza, do you have a question?
Hi, yeah. Can you hear me?
Yes.
Yeah.
Okay, I was curious, when it comes to serving a person who lives on like tribal land, would the electronic service, is that an option for that? Or do you have any other suggestions? Because typically process servers I've spoken with don't or can't serve on tribal land. What would your suggestions be if you're trying to serve somebody who lives in that situation?
All right. So, 2 questions. Is the person that you're trying to serve a registered member of that tribe?
I'm not sure. I'm talking more generally, so I don't have like a specific case in mind.
Okay. The court rulings are going back to Franco, let's say. And Franco addressed the sheriff and the constable's authority to be on tribal land serving legal process. It had nothing to do with process servers whatsoever. And basically, if we are serving on tribal land and it's a member of